time, that's just the time that you have law enforcement. Also, we had an attorney misplace a watch at security. So if you were someone who took off your watch and put one back on, if you could just check and make sure that it is yours.
Is it a nice watch?
No idea. I was just asked to.
I'm not sure what mine looks like,
interpret
so
that.
I'm just checking.
I don't know. But yeah, that if you happen to find it,
You're
or
out.
find that you don't have your watch, you have someone else's, The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. Welcome. We are happy to have you with us today. We will hear argument first in Cross River Bank versus 3B's Assisted Living. And Mr. Bardos, whenever you're ready.
Good morning, Your Honors. May it please the Court. My name is Richard Bardos. I represent Connie Stewart and 3B's Assisted Living in this appeal. We are the appellant. So this case comes down to sort of an interesting question raised by the court, whether whether the contract was ambiguous as to the status of the borrower. The contract, frankly, is not ambiguous. It is plain as day that she signed only on behalf of her corporation. If you look at Joint Appendix 127, you see that the borrower's name, it says borrower's names and signatures with the S's in parentheses. There is but one signature there. And then it says, by signing below, each individual or entity becomes obligated under the note as borrower. Again, only one entity signs this. And it says, printed, 3B's Assisted Living by Connie Stewart. Doesn't say and, doesn't say including, doesn't have a second signature line. It has only one. The magistrate judge in this case found that that single signature somehow managed to be two signatures, managed to bind two entities, even though there was only one signature. And under Maryland law, that one signature applies either by statute, if this court finds that she signed unambiguously as the principal of this company, or under Maryland corporate law, which holds that when a person signs on behalf of a company, it is a corporate act, not a personal act, unless there's some other issue, and there's no other issue alleged in this case.
So now I'm looking at JA 122, and this is the note, and it says borrower, and it says Connie Stewart. What do I do with that?
That is true, Your Honor. That is the only place in all of these documents that is done. That was a document drafted by the bank, and every single document drafted by the bank, other than that, specifically lists 3B's Assisted Living as the borrower.
I'm just saying that seems to be a pretty bad fact for the claim that it's unambiguous that she was signing only in her representative capacity when I'm looking at a document that literally says borrower Connie Stewart.
Yes, Your Honor. So one option for the court, from my perspective, is to say this was unambiguous in my favor. Another option is to say it was not unambiguous. There's some question here, right? Because there's a document, as Your Honor said, that says borrower in one box that the bank prepared, but there's 8 other places in which the bank acknowledged that the borrower was 3B's Assisted Living.
And I guess the other thing that's sort of hard for the argument that it's unambiguous, that she's not signing in a representative capacity, is that there's Maryland case law that says if you want to make it unambiguous, you can say so-and-so on behalf of or for, and it doesn't say that either. It says her name. I agree with you that the document you referenced doesn't say she's not signing in a representative capacity, but there's also Maryland case law that says, like, if you want to make it really clear, you just say so-and-so on behalf of or as an agent of, and it doesn't say any of those things either.
It says by, which I agree is not as clear as what Your Honor is saying, but it does say by, suggesting that, and it says 3B's Assisted Living by Connie Stewart. So there is there's the corporate name, and the only way a corporation can sign anything is by a human being signing their name, and that's what happened here. But let's say, Your Honor, that it's not unambiguous in my favor. The problem here is that this is not an appeal from a trial where a jury or a judge heard all of the evidence and decided what this meant. This was a summary judgment ruling by a magistrate judge in which that judge said that it was unambiguous in favor of the bank. So if I can apply Judge Henton's your argument, if there's one document that prevents it from being unambiguous in my favor,
Sure.
I got 6 documents that prevent
Okay, so let's say that my gut reaction is that it's not let's just, for the sake of argument, say my gut reaction is this is not unambiguously anything. So walk me through how you think you should do the analysis if my gut reaction is this is not unambiguously anything.
Oh, yes, certainly, Your Honor. So
Do you think, for example, does this statute that's talked about in the briefs, does that bear on it?
if your
Maryland
hypothetical,
3402, right,
yes,
specifically.
if your hypothetical is that it's not unambiguously signature by the corporation, then that statute would not apply. What you then have is an ambiguity in the contract. And once you have an ambiguity in the contract, two things happen. The first is it's inappropriate for summary judgment. This court has held multiple times that it is an exceptionally difficult task to grant summary judgment when there is an ambiguity. And there is no writing that is unambiguous if it is susceptible to two reasonable interpretations. That's from Worldwide Rights versus COMBE 955 F. 2nd 242. So once you get to the point where it's ambiguous, then you look at the rest of the documents and you try to determine what the intent of the parties
Well,
was.
just help me walk through this statute. So if you're asserting that we would then be under 3402, I presume we're under B, and then B1, there's B1 and B2. B1 tells me what happens if it shows unambiguously that it's on behalf of the representative party. You obviously don't think this is a B1 case, right? Is that where you think it, well, your first order argument is that it is.
Yes, sir.
But your fallback argument is that if it's not, we'd go to B2, right?
Well, we go to B2 or we go to Maryland common law and corporate, and how corporate.
Wait,
Well,
we'd start
which?
at, wait, sorry.
I mean, which do we go to? Why don't we go to B2? Why do we go to something else?
Well, because I think both of them apply here.
And they're consistent in your view?
Yes. Under Maryland corporate law, if a person signs on behalf of a company, they are not personally liable. The question is, if this is ambiguous, is that what happened? So if you look at the documents, the loan application is from 3B's Assisted Living. The terms document is from 3B's Assisted Living. The application form says 3B's Assisted Living. The form filled out by the bank that has borrower in the top left-hand corner, which is JA115, has borrower 3B's Assisted Living. So once you get to the ambiguity, then you have to look at the rest, this court and the Maryland courts have both said, then you look at the rest of the documents, the rest of the evidence. We never had a chance to do that. This magistrate judge, without a hearing, decided on his own two things. First of all, that it was unambiguous in favor of the bank, but more importantly, that two different entities were liable here when two different entities never signed the document.
Counsel, let me ask you a question. I did have a little bit of trouble following the district court's reasoning, but I think it's possible at least that what the magistrate judge found turns on this, the joint and several liability provision, that by signing below, each individual or entity becomes obligated under this note as borrower. Why doesn't that, the background Maryland law, I agree with you, the sort of default assumption is that if you're signing as a representative, you're not personally liable, but the parties can contract around that. And why isn't that what they've done here? Why isn't this a bank saying, look, like, I don't want to be in litigation for the rest of my life about, with these small businesses, who's liable, the owner or the business? I'm going to write something into the contract that says, doesn't matter, if you sign your name, you're personally liable.
Well, because what it says is the entities or individuals who sign below.
Right, and she is an individual who
But she
signed
didn't.
below.
Right, but there's only one signature, and that's the entity that's the company. If Your Honor.
I guess I'm saying, why can't you read this provision? I actually understood, to the best of my guess, that the magistrate judge was saying, look, she might have signed as a representative of 3Bs, but it doesn't matter, because she wrote down her name, and this contract has contracted around the default rule that if you're a representative, you're not personally liable.
Well, I think if they're trying to get around both the statute and the common law in Maryland, they need to be a lot more precise than that, number one.
It's pretty precise. Anyone who signs is obligated.
Yes, but if that were true, then they could put that in a contract, and every single corporation that ever signed an agreement, the person would then be personally liable. That
Yeah,
is-
right.
That is the opposite.
Of the
what-
default rule, but you can contract around it. You can move on, yeah.
I don't disagree with you. I think that in this context, there are so many other indications, but that is not what Ms. Stewart was doing, both by her signature at the end and all the other documents that list her company as the borrower.
But I'm saying, even if her company was the borrower, couldn't the bank insist that if you want to sign on behalf of the company, you too will be personally liable.
Yes, and I think they could have done that, but I don't think that is clear enough to hold her personally liable based on that one statement. Plus, at the end it says, by signing below, each individual or entity becomes obligated under the note as borrower. And there's only one entity listed. So if they wanted to do, Your Honor, what you're suggesting, they simply have to have a separate signature, a second signature line. It's not a complicated process.
Can I go back to the statute? Because I'm going to preface this by, I'm not sure you've preserved an argument under B2, because when I read your brief, I really only see reference to B1. But I just want to walk through how this would work under B2. So B2 says if it's not unambiguous that the signature is made in a representative capacity, let's hypothesize that I think that for the sake of argument, the representative, and then the next clause is about a holder in due course. Do you think that the appellee here is a holder in due course?
No.
Okay, so because they're the issuer, they're not a holder in due
That's
course?
correct.
Okay, so then if B2 applies, we'd go to the last sentence, and then the last sentence says, with respect to any other person other than a holder in due course, the representative is, that's your client, is liable under the instrument unless the representative proves that the original parties did not intend. So you agree that if that sentence applies, it shifts the burden of proof to your client to prove that she's not this, right?
Yes, sir. And we never had a chance to do that.
Well, but did you ever assert that B2 is the governing rule here? When I read your brief, the only references I see are to B1.
So two things. I did not reference B2 because I thought our stronger argument was under the
Sure.
unambiguous. Secondly, I wasn't counsel when this matter was brought before the magistrate judge. I know that it was raised, sort of, but I don't believe it was raised in full. It wasn't raised in that statute. And I asked the judge before he ruled if I could supplement. He said no. I did file a motion for reconsideration, but as the court knows, those are rarely granted. So we never really got to that. And that's exactly why we're here, right?
But earlier you said that the common law and B2 are one and the same, so it really doesn't matter which we're under, but I don't think that's right, because under B2, your client has the burden of proof. If it's ambiguous, you lose, because you haven't.
I'm sorry, Judge Harris, I misunderstood your question.
Okay.
I thought you asked if they were consistent. I think they are consistent.
Okay.
I don't think they're the same.
But do you think that do you agree that if we're under B2, the burden is on your client to show what was going on, whereas if we're under the common law, if you can't tell what's going on, it goes to a jury?
Yes, and we were never given the opportunity to do that. I agree with you, and I think we can meet that burden very easily by these documents, if my client ever had an opportunity to explain what was going on.
Who do you think, if we're in B2, sorry, I'm just making sure I'm understanding. If we're in B2 land and the burden is on you, who is the decider then? Is that a question for the court, or is that a question for a jury?
So as I read the cases, I mean, I would hope to be in front of a jury, but as I read the cases, the question on contract interpretation generally is done by a judge, but it's done by the court after a hearing, right? After we have an opportunity to present our witnesses and explain things and show the judge our position on this and meet the burden that Judge Harris is talking about.
So once if we were to decide there's ambiguity, one way or the other, the answer then is it has to go back, and the trial court, whether magistrate or district judge, would have to take evidence and determine what the best resolution of that ambiguity is.
Yes, in addition, two things. First, they would have to have a hearing, take evidence, listen to argument, but more importantly, what the magistrate judge didn't do here is what is required when assessing an ambiguity, and that is looking at the rest of the documents. There's nothing in the judge's opinion that says, well, I looked at the point where the bank said the borrower was 3Bs, assisted living, and I don't think that counts because of this. There's nothing in the judge's opinion that says that. So yes, we would be in front of either a judge or a magistrate judge, but we would be able to present our position. We would be able to present evidence. Ms. Stewart could take the stand and say, here's what happened. Here's who I talked to the bank about. Here's how we got in this situation.
Do you agree, though, that with B2, again, assuming for the sake of argument we're in B2 land, it says, unless the representative proves that the original parties did not intend. So you agree that's not just a question of what your client subjectively believed. It's what the parties mutually agreed, if anything, right?
Yes.
So hypothetically, if one could show that your client believed she was signing in an individual capacity, but the bank thought she was signing in a representative capacity, and there was really no meeting of the minds, if your client has the burden of proof, she would then lose, right? Because she could not prove that the parties did not intend something.
If the court found that both parties were equally credible and that the
No, they're both being totally sincere. They're both saying, she says, I did not believe that I was personally liable, and the bank officer says, I absolutely believed that she was personally liable. And then the court said, well, did you ever, like, hash this out to figure out what it was? And then they say no. That's all the evidence. The court believes all that evidence. Your client would then lose, right?
I think that's fair.
Okay.
I hope that's not the outcome, but I'm basically a criminal defense attorney, so I'm pretty familiar with the burden of proof.
Yeah.
I usually don't have it. I have it in this case, and I see my time is up.
Oh, I do have just one very quick question about the statute. So the statute only applies to negotiable instruments? I do not remember this part of law school. Is it 100% obvious that this is a negotiable instrument and not just a regular contract?
I believe everybody has agreed that it's a negotiable
Okay.
instrument.
Cool, thank you.
Just specifically that the note is a negotiable instrument. What the negotiable instrument is the note?
Yes, sir.
Okay.
Yes, sir.
Thank you.
Thank you, Your Honors.
Mr. Lerner, whenever you're ready.
Thank you, Your Honors. Are you ready?
Yes, please.
Okay. Jonathan Lerner on behalf of Cross River Bank, the plaintiff appellee. I'm glad we were discussing the promissory note, because that's what I wanted to bring up as that's the main document in this transaction. And a couple of things I wanted to point out. First of all, this document, this was originated by the SBA, not the bank. So if you look at the appendix, page 122, it has the SBA logo on it. There are many of these, many PPP loans that happened in that time period, and these terms are created by the SBA.
Is there, in the SBA program or in the bank's experience, is there any example of a business and its owner being held jointly liable? I understand what I think is ambiguity in this one, but given how many of these SBA, PPP loans exist, does the bank have other examples where they have held the owner and the entity liable? I mean, that seems like a highly unusual thing to do, just as like a generic matter, absent sort of specification, right? I mean, sometimes you do require such a promise, but in loans as a general matter, that doesn't seem to work that way. But is this like a common practice? So, if discovery came out, would the bank be able to say, yes, we've held the owner to be responsible in every single one of these PPP loans? Because the regs don't seem to suggest that, and maybe you could read the contract that way, but it doesn't seem like that's the consistent pattern.
I don't know of any examples of that happening, but I did want to.
But doesn't that tell us something about the state of mind? I mean, if we got to this question of ambiguity, wouldn't it tell us something about the state of mind? If for example, your bank, every other one correctly listed the borrower as the entity and not the agent of the entity, and every other one of these like correctly shows that it's the entity and not its representative, wouldn't that sort of suggest something to us about the state of mind of what was going on? So I guess what I'm sort of asking there is, how can we decide this without like fairly extensive discovery into your bank's practices with other loans, right? How you treat other loans?
I've been involved in other cases where the bank was recovering loan money, but I don't recall it. I don't recall any that had this issue that we're dealing with today. I did want to point you to paragraph 9 in the promissory note. You've seen, I'm sure. This is page 126, just a few pages after the beginning. It states explicitly, all individuals and entities signing this note are jointly and severally liable. And the trial judge even cited that in his opinion. And so it's explicitly clear that Connie Stewart and 3Bs are both liable, not just one.
Can I ask you just some framing questions about, like, some of them I asked your friend on the other side, see if we can get agreement. Do you think that this is a negotiable instrument?
It's unclear how this got processed, because as you know.
This feels like a fairly straightforward question. Do you believe that this note is a negotiable instrument within the meaning of Maryland Code 3402?
I don't know the answer.
How can I decide this case if I don't know if this is a negotiable instrument or not?
I mean, it's.
Because if it's not a negotiable instrument, 3402 is irrelevant, and if it is a negotiable instrument, 3402 is super important.
It's certainly a contract, and is it negotiable in what sense? That the
As
term-
defined in the same provision of the uniform, I mean, I think this provision of the Uniform Commercial Code defines what negotiable instrument means, right?
That the terms are changed, that the terms change in the transaction? Because I think these are the standard terms. I don't see anything in here that changed.
Okay, let's assume for the purpose of argument that it is a negotiable instrument. So now I don't understand how what the district court did is remotely consistent with the statute, because I look at B1, and the statute tells me what to do if the note shows unambiguously that the signature is made on behalf of the representative party, and just so I can keep this straight. So in this addresses a situation where it makes totally clear that she's signing on behalf of the business and not herself. It says in that situation, she's not liable. But what the district court, to me, seems to have read it as saying the opposite. The district court seems to say it is unambiguous that she is signing in her personal capacity, and that means she is liable, but that is not what B1 says. B1 addresses the opposite situation, right? So if it's not a B1, so I don't see how for you it can, I mean, your friend on the other side could win if this is a B1 case, but you can't win this case under B1 because B1 doesn't address the scenario where you win. So then we'd have to go to B2, okay? So next question, do you think that your client is a holder in due course?
If it's unclear, I can't.
Well, again, I literally can't apply B2 unless I know whether your client is a holder in due course, because B2 has different rules for holders in due course and for people who are not holders in due course.
I mean, again, I think that the trial judge, and he cited that clause that I quoted.
Which
That-
clause?
That paragraph 9.
I'm not talking about paragraph 9, I'm talking about the statute.
Because it's very clear that the term is very clear. They're jointly and severally liable. So you don't have to,
No, but I'm telling you that I think that under this statute, that would just be, if this statute applies, it would be totally wrong, because this statute doesn't say if it's totally clear. I read the trial judge as saying, it's totally clear she's signing in an individual capacity. Whether that's right or wrong, that's what I read the trial judge as saying. But even if that's true, if this statute applies, that doesn't mean summary judgment for your client. It means we have to decide which sentence of B2 applies. And under the let's just posit that I don't think your client is a holder in due course. It then would say she's liable unless she proves the parties did not intend, and the magistrate judge did not give her an opportunity to try to prove the parties did not intend. So what do I do with that?
well, there's another aspect which shows that, that she knew she was responsible and in control of the money.
What's
because-
that evidence? So what is the evidence that she knew she was personally responsible?
Because literally the day the money came in, 1.7 million, she moved over $1 million out of the account
So that might establish that she's a thief,
to herself and
right?
to
That
her
might well
family
establish
and-
she's a thief,
and
right?
other
And that might
entities.
well subject her to criminal liability. I understand that. But why does that tell us that she knew she was personally liable for it? Like, I totally get why, you know, the U.S. Attorney's Office might be interested in that move, but that doesn't tell me anything, it doesn't seem like, about her understanding of her personal liability under the note. So
Well,
is there any other evidence that she knew it? And you just said the evidence shows it. You know, Judge Heitens has pointed to the need for evidence. You says the evidence shows that she had the understanding. I don't know whether that would like suffice, but what is the evidence other than, okay, she stole the money, fine. What else do you have that suggests that she had that understanding?
I think it's clear that if she moved all the money around and used it for, and she opened up new accounts and immediately, and moved the money to other businesses, entities that she owned, and then a few days later, she created a new 3Bs entity. Instead of an LLC, she called it a corporation, and created that and moved some of the money there.
Just, I'll give you, explain to me, totally understand why that's fraud, and totally understand how, if all of that is true, she may well end up in prison as a result of it. Totally get that, right? That doesn't seem hard here. And as a result, she might not be interested in testifying. I understand that too, but that would be her burden. But why does that suggest anything at all about her understanding of her personal liability under the note, right? I don't get the connection between these two. One, like, she may well be a criminal, but that doesn't suggest her mental state with respect to, like, the note, does it?
No, I mean, it doesn't directly say that, but she.
So the point of this is, when you said the evidence shows this, what we really have is no evidence on that question. And so if that is the question, we would have to develop evidence of it. It might require some evidence and discussion from her. It might require it from your bank to the practices that y'all engaged in with all of these loans. Those all seem like areas that are ripe for discovery and discussion to determine what the evidence shows. But what we don't have here is any of that evidence.
Well, I honestly, I don't think we need to prove that because, again, the terms of the note make it clear that she and the entity are jointly and severally liable. I just think it shows you that in the big picture, she was aware that she had control of the money and she could do whatever she wanted with it, and she
Nobody
did.
denies she had control. She controls the entity. Like, she would have control of the money whether she's personally liable or not. Those are just like non-responsive answers.
So I just think that the terms of the note are very clear, and it even spells out, not related to this issue, but in paragraph 1, it actually spells out the amount in words, and in many places, she's alleged that she didn't know the amount of the loan because there were no decimal points or commas on the numbers.
Can you tell me how, or can you describe to me how that amount was arrived upon by your bank? That doesn't seem to be the amount that was requested, and then your bank sort of writes somebody, whether the entity or her, seems like the check was made to the entity, but how did the bank arrive at $1.7 million, given the documentation that she provided?
I don't have definitive proof of it, but I think it's pretty clear that during the process that Connie Stewart or someone helping her adjusted the number from, because it should have been 20,000 and it ended up being 1.7 million, which
So
is
you think,
absurd.
did she break into the bank to do that? Like, how did, like, I don't understand that, right? So she submits it saying $20,000 and the number moves to 1.7. Did she do that in your computer system? Did she like hack in, or?
I think she did it while she was online applying for the loan. But again, we
So the
don't.
borrower typically, your bank operates, I mean, you might want to think about saying this, but your bank operates where the loan amount is only inputted by the borrower? The bank doesn't control the loan amount? I can just pick, if I apply for a loan, I just pick whatever number I want?
Well, they should have realized that it was a mistake. I mean, I'm not, they weren't intentionally calling it a $1.7 million loan, because on page 1 of the application, it shows that she only had 8 employees, and the monthly payroll was only $8,000.
Does the bank get compensated based on the total amount of loans that it issued under this plan?
The bank would normally get, the SBA would be a guarantor, and will probably reimburse the bank $20,000, which was the real amount that the loan should have been. But they're not gonna reimburse the bank $1.7 million.
Can I take us back to the negotiable instrument question? So I'm looking at 3104A, which defines what negotiable instrument means in Maryland. And it basically says, negotiable instrument means an unconditional promise or order to pay a fixed amount of money with or without interest. So do you agree this note is an unconditional promise or order to pay a fixed amount of money with interest?
I think it is, yeah.
Okay, and then it says, is payable to bearer or to order at the time it is issued or first comes into possession of the holder. And I'm looking at JA 122, and I see paragraph 1 labeled promise to pay. In return for this loan, borrower promises to pay to the order of lender the amount, and then it lists the amount. So do you agree that the is payable to bearer or order condition is satisfied?
Yeah,
Okay, it then says 2, is payable on demand or at a definite time. And now I'm looking at 123, where it says you have to pay using the following payment schedule described in this document. So do you agree that clause is satisfied?
yeah.
And then the last one says, does not state any other undertaking or instruction to the person promising or ordering payment to do any act in addition to the payment of money. And then it says a few other things that are exceptions. But does this document do anything other than promise to pay money?
It may mention the forgiveness aspect of the PPP loan.
But it doesn't make like other contractual promises. This isn't like promise to pay money and also promise to like paint your house and also promise to like employ you. This is just like you're lending her money, you're lending her or the business, I know that's what we're here to decide. You're lending someone money and they're promising to pay it back on certain terms. There's not another series of promises, right?
Right.
Do you think the forgiveness piece of this affects it? I mean, I can't tell if that's what you're saying, whether you're suggesting to Judge Heidens that the forgiveness piece of this program makes this not negotiable for some reason, because it's not a certain promise to pay?
No, I wouldn't say that, because the forgiveness program is, you have to use the money for payroll and other business expenses, and obviously payroll being the main use of the loan funds. And her payroll was minimal, so how could she use 1.7 million for payroll? You know, she ended up transferring the money around and buying a house and all this kind of stuff.
Is the forgiveness piece included in the note itself, or is the note a negotiable instrument that doesn't refer to the forgiveness? So that the forgiveness program is really a distinct item.
It's, it may be just a regulation that is separate from this note.
Well, it may be, or is it? It is.
And there's also in the
No,
application.
sorry, that's a question. That's a question. You said it may be, but let's assume for the sake of argument that I think it might be relevant, whether it's part of the note or external to the note. Which do you think that is?
Well, it's definitely relevant. I'm just looking in the note to see if it's in here, but there are other documents relating to the transaction. There were, in the loan application document, it does list other rules and clauses. But again, there's no way that this would, that she would be approved for forgiveness, because the amount issued by the bank was extraordinarily higher than the payroll situation. So if you have any other questions, I'll try to answer them.
I think we're all set. Thank you very much.
Okay, all right, thank you all.
All right, Mr. Bartos, you have some time on rebuttal.
Oh, looks like I just ran out, unless,
No, I'm sorry. Mr. Lerner, thank you very much. And Mr.
Thank you.
Bartos, you have some time
Thank
for
you.
rebuttal.
Thank you, Your Honor. So,
Can I ask a procedural question before you
Of
get
course,
started? Do I understand that you have appealed only the contract claim? There are lots of other things that are potentially at issue, but that count one, which is a contract claim, that's the issue that you've appealed?
yes, sir.
Okay.
So, to answer Judge Richardson's question about other loans, as I said, I do a lot of criminal defense in federal court. I've handled a lot of PPP loan cases. I've never seen anybody going after personally because it is the Paycheck Protection Program. It was designed for companies to obtain loans, for those companies to pay their employees. It's not a personal loan. It was never a personal loan. That's the first thing. The second, with regard to forgiveness, that's not in the note anywhere. The forgiveness program is a completely separate thing that the SBA said, look, if you get this Paycheck Protection Program loan and you can show us that you spent 80% on payroll, we will forgive the loan. That's where it has nothing to do with the bank. And you are absolutely right that my client, on behalf of her company, filed an application for a loan for $20,000. That's what she did. The suggestion that she somehow, or anybody somehow fraudulently sought 1.7 million is simply incorrect. That was a bank error. It's been a bank error from the beginning. And what the bank is doing is they're saying, we made a mistake. We're not going to get reimbursed by the SBA, so we got to go after this woman. That's really, I think, why we're here. But the forgiveness program is not part of what the bank does. Because in a normal, proper PPP loan situation, the bank makes the loan, and this is why the banks made all these loans, right? They get a commission, and the SBA pays them back. So there's very little risk to the bank if they do the right thing. If they do the wrong thing, the SBA says, as they did in this case, we can't give you $1.7 million. It was never appropriate to give that money out. So the forgiveness program is separate, but the Paycheck Protection Program is clearly designed for companies to be able to pay their people, and the companies are the ones who are the borrowers.
Just, oh, sorry.
Go ahead. Okay. No? Okay.
And I did have an opportunity, Judge Haytens, I apologize for not doing it this morning, to reread the B2. And frankly, I should have mentioned it a lot stronger in my brief, or mentioned it at all, really. But I think you've hit on exactly what the problem is here. There may be a question, as Judge Harris pointed out, on this one line in the note with regard to who signs and who's liable. But summary judgment on this issue, I think, is grossly inappropriate, particularly given that, and I haven't even asked for this before, but I'll ask for it now, that the magistrate judge was supposed to look at this in a light most favorable to my client, not most favorable to the bank.
Do you agree that if you go back, in order to meet your burden, that your client would have to testify, and that creates some potential problems? You're a criminal defense lawyer, but that's what you want to do. You want to go back and your client be given the opportunity to be put under oath and ask questions about what happened here.
Yes, sir. And I also know that the U.S. Attorney's Office is aware of this situation, has not filed any charges, does not intend to file any charges as far as what they've informed me. They did file for forfeiture of the house at one point, but they've withdrawn that now because I told them, look, we're in front of the Fourth Circuit and they're going to decide this case, and you can't, so they're well aware of it. I understand the concern. I have advised many a client on the Fifth Amendment. I'm pretty familiar with it, but I don't think it applies in this case. I could get into the details, but I'm comfortable with that. And I believe that my client filed an affidavit under oath that said, I applied for a loan in this amount, I got this amount. She obviously went to a lawyer and said, what am I supposed to do with this money? The lawyer said, you can spend it on your business. That's a whole separate lawsuit. But to answer your question shorter, no, I'm not as concerned.
Counsel, just to go back to Judge Richardson's question, you're only appealing on the breach count the district court also granted summary judgment on fraudulent conveyance, different count, but is your view that that just sort of follows the breach?
Yes, yes. I think all of it does, yes. Unless there are other questions, thank you all very much.
Thank you. We will come down and greet counsel and then go on to our next case. Everyone can be seated. I'm sorry. All right, we'll hear argument next in number 241734. And hear first from the appellant, Mr. Poon, when you're ready.
Thank you, Your Honors, and may it please the court. The government's position in this case is that it can violate the Constitution issuing a rule, and then when challenged, it can moot the retroactive action and then keep violating the Constitution. Here, Mr. Roush issued the approach rule.
I mean, in fairness, that's not really the government's position. The government doesn't think there was an appointments clause violation.
At this point in the proceedings, we do assume that there is an appointments clause violation due to the bifurcation.
Okay, but in characterizing their position, I don't understand them to be saying that they would like to continue violating the Constitution because they don't think they did.
I think what we see in the government's behavior is that it's trying to shield itself from judicial scrutiny, and that's what we see in Moose Juice as well, is that after the proceedings concluded, they only ratified in order to stop the courts from reviewing the delegations there. And the government's behavior, if it really didn't believe that it didn't violate the Constitution here, it would proceed to the merits.
I mean, it's sort of weird. Like, basically, you sue, and then the agency gives you the relief you are asking for. Instead of the civil servant, we're going to have the rule adopted by a duly appointed, politically accountable officer, and that's a bad thing. Like, we should be worried about that.
Yes, Your Honor. We did not get the relief we were asking for. The relief we asked for was for the rule and the delegations to be vacated, and in order to avoid that, the government took illegal, unauthorized action to ratify. And if we're talking about whether the values underlying the appointments clause have been vindicated, they haven't been. The delegations still exist. Rules are still being issued under those delegations. None of the other rules have been ratified. It's clear if we look at all of these circumstances that what we're seeing is gamesmanship. The government is just trying to avoid judicial scrutiny.
So can I, in terms of relief, I think this is true from your complaint, but I just want to confirm it 100%. Am I correct that the only relief you are seeking is prospective?
The only
In the
relief-
complaint?
That's correct, Your Honor.
We're not asking for damages,
Yes.
so this is a Los Angeles versus Lions type, all I want is an injunction situation, right?
We're only looking for an injunction, and this, I think, is similar to cases like St. Cyr or Ward versus Dixie, where the issue, the harm is also in the future, but nevertheless, there was, this harm was created by a retroactive action by changing this.
Okay, but what I don't understand is how, let's bracket. So the rule is issued, and it's issued by someone, fine, let's assume for the sake of argument it was unauthorized during that period. But then it's issued by someone who we assume does have the authority, would have had the authority to do this in the first instance, right? There's been no challenge that the ratifier would have not had the authority to issue the rule in the first instance, right?
Correct.
And so then he ratifies, and now we're in the post-ratification period. And you agree that sitting here today, we're in the post-ratification period, right?
Yes.
And you want us to enjoin that rule, right?
Well, the original rule.
No. You want us to enjoin, you want us to issue an injunction that would by definition only go forward in time, right?
Sure, yes, against the approach rule.
So
yes.
the injunction would only affect things that happened post-ratification.
Yes.
How in the world is that retroactive? That seems like literally the opposite of retroactive. That sounds like the definition of prospective to me.
So what we're talking about is a prospective effect from the approach rule. The requirements of the approach rule, so the requirements of you can't approach a dolphin, you can't swim with it, that comes from the approach rule. And the approach rule is only, if the ratification is effective, it's only effective because the ratification reached back. It's not that the rule is retrospective, it's that the ratification is retroactive. And because the
But how do I know that? What if the ratification said, from this day forward, this rule is approved by me? So you're telling me it's just the literal language of the ratification? Because what if the ratifier just said, from this day forward, the rule is valid? I'm reissuing the rule under my authority.
They could have done that. They could
Isn't that
have.
pretty close to what they actually did here?
No, Your Honor. What that would be a new final rule. What they chose to do was ratify as of, the language says from the ratification, as of September 2021. They chose the form of ratification, which is inherently retroactive. It authorizes a past act as though it had been authorized from the beginning. And it made this choice in order to obtain the benefits, and it has to be held to that. Under Chenery, it's not fair for litigants to have to be able to defeat everything that a government official might have done. The government chose one thing. That's the only thing we have to respond to. They explicitly decided not to do the other thing. They acknowledge in their brief they could have issued a prospective rule. They chose not to. There's no reason for the
Have
court
you
to.
identified a single federal court of appeals that says that ratification doesn't cure an appointments clause problem?
There is not a single federal court of appeals that has confronted whether
And the
there
DC
is.
Circuit has specifically said the opposite?
The DC Circuit has not specifically said the opposite. It has not said that there is statutory authority for ratification. And there has to be statutory authority for everything an agency official does.
And what is the authority for the view that there has to be statutory authority for ratification? Because I also don't see you identifying. I mean, so concretely, for example, in fact, there seems to be a problem, because there is one statute that says it's not, and that's the Vacancies Act, right?
The Vacancies Act says that certain things cannot be ratified.
Okay, well, why doesn't that seem to suggest a generally applicable principle that unless we say things can't be ratified, they can be ratified?
Because there's a clear statement rule for authorizing retroactive actions.
Where does that come from?
That comes from Bowen and the Landgraf line of cases.
But in Bowen, everyone agreed the act. Literally, paragraph 1 of the court's opinion in Bowen starts by positing that what's involved is retroactive, right?
Sure. Just,
Bowen doesn't hold what happened was it's a premise of the court's decision in Bowen that it was retroactive.
Your Honor, we have hundreds of years of case law from every court across the land that says ratification is retroactive. It is inherently retroactive. Literally what it does is, the point of it is to retroactively authorize a past act.
Doesn't that then seem all the more surprising that you can't identify a single case from any federal court of appeals that says you can't do exactly what the agency did here?
I think ratification hasn't been used by the agencies until quite recently, and so we don't have that many cases to begin with. So no one has raised this fundamental issue. And with respect to the FVRA, Your Honor, I think I would point you to Landgraf and St. Cyr, where there were even stronger negative inferences that you could draw, where there were provisions in those statutes that explicitly said, we are going to apply the statute prospectively in these circumstances, which would imply that other that there would be retroactive application otherwise, and the court rejected this kind of negative inference in both of those circumstances. It said that the Congress has to provide for retroactivity with unmistakable clarity.
Can I ask you a slightly different question, which I think is maybe not an argument that you've fleshed out, but you don't seem to rely on Lucia and our court's decision in Brooks, which both address sort of ratification of the appointment of ALJs. But I wonder if you just have a comment on this idea that Lucia, and then we make very clear in Brooks, that the ratification of the ALJ doesn't do anything to affect the ruling, in that case an adjudication, that the ALJ had made. That in fact, Lucia and Brooks say it has to be done anew by a new ALJ, and so that the ratification of the ALJ's appointment doesn't solve the problem. It seems like that could be the argument you're making. I'm not sure that it is exactly, but y'all are good lawyers. I'm sort of curious why that's not the argument that you're making.
Your Honor, in Lucia, our understanding of these ratification of appointments cases is that they're not really reaching back and saying this person was always properly appointed. It's a black stick.
They say that that's what they're doing, right? And in Lucia, in the footnote, the court sort of ducks the question, right? But our court in Brooks takes that question up and sort of says ratification, what you call retrospective. I'm not sure that's actually what's happening, but this ratification doesn't remedy the problem. And I would have taken you to be sort of trying to make a version of that argument, which is ratifying going back, doesn't solve the appointments clause problem in the same way it didn't in Lucia and Brooks.
That is true. I think that's our third argument, where what we get with ratification, we know that's giving authority to someone to do a past action. And the whole point of the lawsuit is that no authority is allowed to be no rulemaking authority is allowed to be given to Mr. Rausch because he's not properly appointed. So whether you do it retroactively or whether you do it prospectively, which in fact Mr. Spinrad did do through the delegations, there is an appointments clause violation.
Can I ask you a question about the, how your theory applies to the appointment of the ratification of ALJ appointments? That's not retroactive in the same way, and why is that? Because I do think that what the agencies understand they are doing is saying your appointment is ratified, and that goes back to the day you were appointed. You may have to have a new adjudication, but it's not like you were not an ALJ in the interim. But you see it differently?
My understanding of those cases is that the ALJ's ratifications are going forward. We see.
What makes you say that? Because I don't remember perfectly from our K&R case, but I'm pretty sure that the ratification there said, no, you're ratified as of the date of your original appointment.
I think what we see.
And that's how we talked about it in K&R. We said that the ratification cures any constitutional defect in the prior and original hiring. So I think we have conceived of it as retroactive in that sense.
I don't think that there was the sort of retroactive effect in those sorts of cases where we say, okay, and so all of your decisions
I agree,
are now.
but I understood the theory of ratification, of retroactivity that you were describing to us today. It seems to me it would also render all of those ratified appointments invalid because they purport to do something backward-looking, which is say your appointment was actually proper starting on the day you were appointed. Whether you now have the right to sort of go back and ratify everything you did is a different question. But it is backward-looking in the same way that you are describing today. And so my concern now is whether if we adopt your theory, we are getting crosswise with our own precedent in K&R.
Your Honor, I would say two things. One is that those ratifications don't have an impact on a regulated public. if we're saying, well, those decisions, well, maybe they're not ratified, but it's just the appointments that are ratified, that's basically a completely internal move that
So
the
it's
ratifier.
retroactive, but it's okay because it doesn't have an effect on a party in the case.
That would,
Okay,
well,
so
or
what is
any
the-
effect on the public.
Okay, okay, so if it has an effect on people who are not parties to the case, that's still problematic. Because I will just tell you what I'm trying to figure out is how the kind of retroactive period here had any effect on your client.
Sure, and it does. So one thing it does is it exposes my clients to liability in that case, in that time period, and it's potential liability. But if we look
And
at
that time period, just meaning the pre-ratification time period?
yes, from the issuance of the rule to the ratification, it's that time period. It's about a year, and my clients were in the water during that time. They could have the dolphins are all around in these areas, and so they could have unwittingly violated the approach rule in that time period. And we don't know that they did, but I think I would call your attention to St. Cyr, where
Do you
the,
take the rule as applying to like unwitting conduct? Right,
Oh.
so,
oh, absolutely. Yes, that's clear. That's, the rule is so strict that, I see I'm out of time, may I continue?
you can answer.
The rule is so strict that if you are approached by a dolphin, you are required to flee. So it's not that if you just stand there and or in the water, tread water there, and it approaches you, that you haven't violated the rule. If you just stay there, you have violated the rule, and that comes with civil and criminal liabilities.
How is that unwitting?
Yeah, I don't
Unwitting would be
understand.
like, my back is turned and like, oh my God, there's a dolphin there, I'm liable.
Yes.
But no,
that
the rule says
precisely-
if I realize there's a dolphin there, I have to move away from the dolphin. That's not unwitting.
Well, I think it's if you are in the vicinity of the dolphin, that's unwitting. You're not allowed to.
No, my choice to stay there after I realize there's a dolphin there is not unwitting, because that's staying there knowing there's a dolphin there.
Well, you could unwittingly approach a dolphin if you're just swimming in its direction.
Sure.
Thank you, Your Honor.
Thank you, good.
May it please the court, my name is Robert Stockman, here on behalf of the federal defendants. We ask this court to affirm the district court's grant of summary judgment. I'd like to just start with where the court ended. There's an exception in the rule for any person who inadvertently comes within 50 yards of the spinner dolphin. So it would not apply to someone who inadvertently comes within 50 yards of the spinner dolphin. Plaintiffs have never presented any evidence that they did anything that violated the law during the period pre-ratification. And in fact, I read their materials to suggest they didn't. In fact, that's what harmed them, is that they complied with the law. So it is important to note that there's no reason to think this could ever have any retroactive effect with respect to the plaintiffs before this court. There's just no facts
So
suggesting
I
that.
take that, but just to understand your theory of what ratification is, that it's similar to the agency context, that when the ratification occurred, it made the rule valid from inception.
It makes the rule valid, it relates back and makes the rule valid from the moment of inception.
Totally fair, so I totally get that. And I understand like how that works here. What I'd like some help with is sort of understanding why that theory doesn't run into, or at least cause conflict with Lucia and Brooks, which are our decisions, because both of them sort of say, yes, there's been a ratification of the ALJ, but now you have to go back and redo what was done with a new ALJ. So we would otherwise sort of think that a ratification of the ALJ's appointment goes back to when that ALJ was appointed, and so they were always sort of constitutionally appointed, right? So it reaches back, just like the rule was valid at exception, the ALJ was valid at inception. And if that was true, then it makes it a little hard to understand the remedy that Lucia implies and Brooks commands. which is despite that ratification of the ALJ, we got to redo the adjudication by someone who we now say was like legit.
So plaintiffs did not present this theory.
I understand, but I am.
Yes, no, but I just want to say that.
Yeah.
And I actually think this gets to the fact that the remedy for an appointments clause violation depends on the administrative process, what the precise violation was, and what's at issue.
But my point is different, right? My point is that your theory of sort of using sort of basic agency principles could be, I'm not sure that it is at the end of the day, like your theory could just be inconsistent with Lucia and Brooks. And if that's true, it's not a separate argument, right? It's just like evidence that your understanding of what ratification is mistaken. And so that's what I'm trying to understand. That's like the legal question. I don't want to, join an opinion that like conflicts with Lucia and Brooks. And so help me understand how I would address your argument in light of this.
There is no conflict with Lucia and Brooks, and I want to emphasize it is the fact that a ratification of ALJ goes back, but we have always accepted that to remedy the appointments clause problem, Lucia says that the challenge decision has to have been made by someone who was properly appointed.
But we now know that the ALJ was properly appointed because the appointment goes back in time.
So I don't think that's how ratification would work in that concept. We never presented that argument.
But I took your argument to be that like, once it's ratified, it's as if, right? I mean, my agent goes out, sells a horse on Monday, right? I ratify it on Thursday. It's not that it's good as of Thursday, it's good on Monday. My agent's decision, it's as if my agent's decision was my own.
But that would be ratifying. So when you ratify an action, even at common law, you ratify the action of the agent. You don't ratify the agent completely retroactively, right? That's not how the common law worked. It ratified.
So why is that? I like this. This is the line I hoped you were going to. So why is that? So why do we think about it that way, right? So here, the action that was in Lucia and Brooks, the action that was ratified was the appointment, right? And so now we look back in time and we say this ALJ was validly appointed.
But the challenged action, right? The action was not the appointment of the ALJ.
Was the adjudication.
Was the adjudication and the
But
outcome.
the question we have is, what was there a problem, right? Was there an adjudication by an unconstitutionally appointed person? And if the ratification works like you've suggested, it seems like there wasn't. And yet the remedy.
I think that's mistaking what we're saying about ratification. We say the ALJ it reaches back in that way. But for ratification to apply, like APA cases are against agency actions, right? They're not against the employment decisions or that this person was working at the agency. The problem the court identified in Lucia was that ALJ who made the decision, it was the final decision, had at that time not been appointed. And they said, you need to have an adjudication where the decision is made by someone properly appointed.
Okay, but in the footnote, they say, and I'll stop here and I'll let my colleagues go, but in the footnote, they say, right, they were ratified, right? And if ratification means what you've told me, then that seems wrong, right? Because once they were ratified, when we look back in time, the agent selling the horse, like, was legit, right? The same thing we've got here is the ALJ was legit. I get it seems a little bit like a fiction, but that's because ratification feels that way.
Your Honor is proposing a theory of ratification that is more expansive than the government, to my knowledge, has ever proposed, which is sort of a total cure-all of the past.
No, it's just, I'm not saying it's a cure-all of the past. I'm saying what it did is it cured the action. What was the action?
So the action here.
The ratification.
So the action here was the rule. And what Lucia said is that what someone who has a successful appointments clause challenge should get, the remedy, is a decision by a properly appointed officer. That is what plaintiffs received in this case. Administrator Spinrad came in, looked at the record just as he would have if he had made the decision in the first instance. I mean, rulemaking is different than adjudications. And this is very important. at the final decision, it's all on the paper. So he looks at it and he says, this is a proper rule. I know the record. I make an independent judgment. I'm a public officer. I make this judgment. And so that cures that appointments clause problem. I don't think.
So can I ask maybe this last question and then I'll stop? I'm sorry. Do you think Lucia would look different if what the SEC did was not ratify the appointment of the ALJ, but instead ratified the adjudication itself?
Yes, and it's actually, I would
And
recommend.
why? Why would that be?
So, I think the key thing is it would look different, but because of the nature of adjudications, the SEC wouldn't do that because
Why not? They have the authority to do
Well,
that, right?
they would have to revisit it, right? They'd have to revisit it and they'd have to do the steps that an officer has to do as part of revisiting it. So that could be different. And I think if you read Intercollegiate Broadcasting, which is a DC Circuit case, it really gets into this remedy issue in an interesting situation that is sort of between rulemaking and adjudications. And the point is a public officer has to do the things a public officer has to do. But that doesn't mean you have to start all the way from scratch, but it also means you can't just, you have to do all the things an officer has to do. And one thing the court was saying in Lucia is that ALJs are special, right? They take evidence, they have all these roles that they said, these are the things that make this person an officer. So for the SEC to step in and ratify it, it would at least have to do the things an officer has to do in an adjudication. I'm not familiar enough with SEC law to know exactly where that line is.
The point you're making is maybe to ratify in the adjudication context, they would have to hold a hearing and take evidence and those sorts of things. I understand that distinction, right? But your point is if they did ratify the adjudication in a proper way,
Yes.
then there would have been no problem.
Yes, that's
And
correct.
your argument is the same thing here. Your person did what he needed to do, didn't need to have a hearing because it wasn't an adjudication to ratify the rule itself.
Yes, and I really think Intercollegiate Broadcasting is a great example of this because they had new officers come in and revisit something where prior officers had gone through a lot of process. And the agency found, we have to do these things anew, but we don't have to do everything anew. And the DC Circuit said that cured the appointments clause problem. And I think that's the key thing is I do think it's dangerous. I think plaintiffs' arguments often sort of involve going to a high level of generality. And while that's very valuable, it is important to be in the details of this case and what this is about. And this is a rulemaking. And the great thing about rulemakings is the officer comes in at the end, right? The officer doesn't have to conduct each aspect of the comment process. They don't create the docket. They don't have to collect each study. They look at the full record that's before them, which parties outside get to participate in, and they make a final decision. And thus, Administrator Spinrad was able to ratify because he was doing exactly what he would have done if he had been the final decision maker in the first instance. So I think rulemaking is a context, at least under these statutes, where ratification certainly works. How it works in the adjudicatory context varies, and I also just offer some caution. This court in Brooks, I think, read Lucia broadly to say it always requires a re-adjudication. I think that is generally the rule. But for example, the Ninth Circuit in Decker found that an ALJ had received a case, it was on his docket, but he was ratified a couple of weeks in, long before he'd taken any significant actions. And the Ninth Circuit said, well, that doesn't mean it has to be reassigned, right? He hasn't yet acted as the officer. So there has been no appointments clause violation that needed to be cured.
So is this basically an argument that Brooks is already a pretty aggressive reading of Lucia, and you'd urge us to not go even further with an even more aggressive reading of Lucia?
I would recommend that, and I think Brooks and Lucia I think that's a reasonable reading of Lucia, but I would not recommend going further. And I think this gets to a core issue, which is that a constitutional problem can be cured. A lot of plaintiffs' argument is based on this idea that it's sort of an incurable problem.
So can I take you to the remedy question that for me is actually maybe the hardest question in this case, which is, okay, so let's posit they filed suit pre-ratification, but now we're in the post-ratification period. So to me, the hard question involves the pre-ratification to ratification period. that just strikes me as moot. I know the DC Circuit says that's a merits issue, but to me, that sounds like Article 3 mootness.
So it often, every court to resolve it has said that it is a merits resolution.
Yeah, but I read all the DC Circuit's opinions, and with love and respect, I don't find any of them remotely persuasive in explaining why.
So I think I understand there is a bit of a justiciability question there, right? Is it mootness? Is it that they've sort of, the remedy's already been provided?
You're asking for an injunction against a period of time that is over, involving the validity of a rule whose problem, such as it existed, has now been cured. Everything I'm saying strikes me as Article 3 mootness.
So I think the key thing is that that if that had been the remedy they were asking for, maybe we would be in a mootness world. But of course, the remedy they want is prospective.
Well, no.
right?
So I guess, but tell me, what if anything would be wrong with saying this? To the extent they are at this moment seeking to challenge the rule's validity from the issuance to the ratification period, that is moot, moot, moot. To the extent they are challenging the rule going forward, that claim fails on the merits.
I've not thought about this precise question. I think it's just not presented, right? It's not in the case.
We can't jump past Article 3 mootness.
Well, but I think, that that their overall case loses on the merits is sufficient resolution. The fact that there might be an aspect of something they'd like to argue about that's not presented is moot. I don't think the court needs to resolve because it's not presented. It's not in the case. This is different, for example, than if that were still a live issue in some way, such as they were facing a challenge for actions they had taken during that time.
Like the
but
government
they
is
don't.
threatening to sanction us for something we did during that window.
Yes, and that simply is not present. So because it's not present, I don't think the court has to opine on it.
But I take their argument, maybe he'll explain differently on reply, but I take their argument to be like, the ratification is just void, right? That like, not that it's fixed things going forward, that it's as if the administrator said gobbledygook, right? It doesn't mean anything because he lacked the authority. I'm not saying he's right, but when we think about mootness, we sort of tend to accept that they would prevail on the merits. But if that's true, I might think the argument's gobbledygook. But like, if we thought all that happened here was gobbledygook, then they would, in theory, be entitled to a prospective injunction because, in fact, we would say that the administrator did not lawfully ratify anything, and we would still have this problem going forward in the same way.
So two answers to that. I do think that's one version of their argument is that it's void, and that might, in their theory, form a basis for prospective relief. First, several circuits have wrestled with this argument of, well, it's void, so you can't ratify, and they've rejected it. That's Moose Juice, that's Legitech. It's also the Second Circuit in NLRB, which we cite in our briefs. So the voidness issue has been rejected by multiple courts. But I think their argument to try to get there, they actually are saying that there isn't this statutory authority to ratify. And the problem they face there is that it's not supported. And in fact, if you look at both,
That's a merits question,
That's
not
a
a
merits
mootness
question,
question,
yes,
right?
yes.
Like I understand your merits argument, but we tend to look at the mootness question by saying, if they are right that statutory authority is required, and if they're right that statutory authority is missing, well, then would they be entitled to prospective relief? That seems like a plausible argument.
And that's why, to the extent they're seeking prospective relief, we would say they lose on the merits and it's not a mootness thing. But I think to the extent the question is about, well, what about this period that's now passed? I think there are several problems with that, but one is that it just isn't relevant anymore, right? It's passed.
Why would it be covered by the complaint? Because the complaint is only seeking prospective relief.
It's not covered by the complaint. That's also a challenge. And it's not, this is not that they just failed to plead it. The APA doesn't provide that kind of relief, right? It doesn't provide that kind of retroactive relief for the period you've been subject to a rule during its litigation.
So can I ask you, this is a completely different topic. So I have now just reread again footnote 5 in Lucia, and it strikes me as like where the court explains why it's picking the remedy it does. And I see a lot of very pragmatic language because like, otherwise no one's gonna bring in incent, but you know all the reasons. I read that as just a very pragmatic justification for that remedy. And one of the arguments your colleagues on the other side say is like, think through the implications of saying that this is okay. And they tell a story, and the story is the government violates the Appointments Clause. Someone points out the government violates the Appointment Clause and sues them. The government fixes that violation of the Appointments Clause and then just continues bopping along doing the same thing over and over again. And every time they do something like this, someone moots. That seems to create bad incentives, and at least arguably is in tension with Lucia's, like, we do need to think about, will anyone ever have any incentive to raise the claim if the government gets to do what the government did here? Why should I assume you think I should not worry too much about that. Why should I not worry too much about that?
So first, it's not the case that we always ratify when someone brings an Appointments Clause challenge.
Yeah, but they say you do it quite a lot.
I mean, they say that, but they haven't actually pled that or proven it. And that is important, right? They can say and speculate all they want. If they want to bring some kind of pattern and practice type challenge, they need to plead that and prove it up. And they haven't. And
Okay, well,
it's not as though-
fine.
It's
Oh,
not
but
as-
I was an executive branch lawyer before I was a judge. If I was still an executive branch lawyer, I might just say, get hit with an Appointments Clause challenge, just ratify it, it's fine. Just make it go away.
Well, we do not advise our clients to, if there were an Appointments Clause issue, we would advise our clients to solve it. And the reason we ratified here is in part because if you read Alpha Seafood International, which is just a district court case, but we cited in our brief, in that case, the district court said, it's actually a little tricky to me, this issue of who exactly made this decision. Why don't you just ratify this? And we did, and we solved it. And in many ways, this was judicial economy. It solved everyone's problem here, right? It gave them exactly what they asked for. This is a particularly important rule, or this is one of many important rules. And we decided this was the cleanest course of action that solved everyone's problem going forward.
That's actually very helpful to me. I also was wondering about the decision to ratify, because am I remembering right that your legal theory is that the inferior officer can promulgate the regulations, but there's also a factual dispute about like who exactly had the most say in this regulation, and that's what you're trying, like, that's really not worth the ball of wax.
That was not worth the ball of wax.
String.
And it was much simpler because we could produce a very limited administrative record that just went to ratification. The actual administrative record for this rule would have been vast. So there were a variety of reasons this was in the interest of judicial economy, and it gave the plaintiffs what they wanted. And we thought this was the right course of action in this case. I don't think they have established that this is always our course of action, and I wouldn't say it is to my knowledge. And I just would also like to note that the Vacancies Reform Act does further support our argument. When Congress knows the presumption is ratification, and it knows that and has chosen not to foreclose it generally. I see my time is up. We ask this court to affirm. Thank you very much.
Thank you. And Mr. Poon, you've got time on rebuttal.
Thank you, Your Honor. If a district judge within this circuit delegated case deciding power to a law clerk, and those cases came up, and every time it was challenged, the judge just ratified, this court would not say it's powerless to fix this issue. There is something seriously wrong here when there is a continuing delegation.
Why wouldn't we just think there's no problem? Because it's not the law clerk making the decision, the district court made the decision.
In that instance, perhaps.
Okay,
But if every time it's challenged,
that's fine. If every time the district court actually makes the decision,
that would bring up the Lucia problem because people will stop challenging it. And then there will be this shadow body of law, a shadow CFR here, or a shadow, FSUP below, that would kind of be law because at any point it can be ratified and become real law. Are my clients supposed to bring a lawsuit every time a Marine Mammal Protection Act regulation is issued in order to force the administrator, no administrator, to make a decision? That means there is never actually a final agency action until we bring a lawsuit and until the no administrator actually makes a decision. And in the meantime, are we supposed to comply with these regulations? That's a serious practical problem.
can I ask you a question? I am really trying to figure out the harm here, and I'm wondering whether, does like Loper Bright have a role to play here? Like, if you don't like the approach rule, in the new world in which we live, if you've got, like, why don't you just say, yeah, I got right up close to the dolphin, but I don't think it was a take, so who cares what the regulation says? Like, what's the big deal about the regulation these days? Do you see what I'm saying? Like, the statute's always been the same. The statute is properly promulgated, it says what it says. And now we know that that's really what matters. So I don't quite understand, why is your client in such a fix? I'm sorry, the hypothetical client who wants to swim with the dolphins.
Well, also my real clients.
Okay.
But I think that goes to the statutory authority, that goes to the statutory authority for the regulation, and the appointments clause is even more important. It's about who is regulating us, who has power over our
But
lives, over
they
our
don't have that kind of
professions.
power over you anymore. Congress has the power, and if you think you should be able to get closer to a dolphin than the agency does, why don't you just bring, a case based on the fact that you are both consistent, even though you are out of compliance with the regulation, you are in compliance with the statute. So I just am not understanding why the regulation is, what exact harm the regulation is causing now that is no longer sort of presumptively consistent with the statute, just because the agency says so.
Well, that's a separate claim, I suppose. It's just, we don't think that Loper Bright means that statutes can't support these sorts of regulations anymore. But it is clear that a properly appointed official has to issue them. On the matter of
So,
prospect.
I'm sorry, your real client who wants to swim with the dolphins, does the client think that if he or she comes within 50 yards of a dolphin, they are out of compliance with the statute? I assume your client wants to obey the statute, right?
Yes.
Okay, so is your client of the view that they would like to get closer to the dolphin, and that would be consistent with the statute?
I think, yes.
Okay.
Yes, that's my view, at least. That's
Okay.
what I would advise my client.
Okay, and the statute is what controls?
Yes, the enforcement provisions are from the statute. On the issue of prospective relief, declaratory relief here would also give us retrospective relief as to that retroactive period, because it would tell us that the regulation was not valid during that retroactive period. So it's not.
So I guess another way to think about this, whether it's mootness or something else, here's another way to think about it. Like, I know all these cases that say the essence of a justiciable controversy, right? Article 3 in general is courts can't issue orders that don't have any actual effect in the world. So in this case, how would an order addressing the legality of the rule during the period I've identified have any actual effect in the world?
It would protect plaintiffs from liability during that period, and
But your client hasn't alleged that anyone's threatening to do anything to them based on what happened during that period.
there's an exception to mootness, which is voluntary cessation, which is very clearly what is happening here. That they are voluntarily ceasing their appointments clause violation, and then they have this policy, this delegation is the policy of continuing to issue regulations that will bind my
And
clients.
doesn't this court have a decision saying a declaratory judgment can't solve a mootness problem? Haven't we literally said that in a published opinion?
I'm sorry, that was a second point. The voluntary cessation
Okay.
point is that going forward, they will have.
No, but
this
you
thing.
opened by saying the declaratory judgment
yes,
piece
yes,
fixes
yes.
it. But this court has said if to the extent you have a mootness problem, the fact
Sure.
that you ask for declaratory judgment doesn't fix it.
Yes, the declaratory relief issue was just as to the retrospective, prospective relief question. I'd just conclude by saying that the idea that there is a future effect, that doesn't mean that that there's no retroactive action. I'd point you to Olatunji and Ward, which control here, and I see my time is up.
Thank you very much. We will come down and greet counsel and then take a very short break before the next case.
This honorable court will take a brief recess. The Honorable Judges of the United States Court of Appeals for the Fourth Circuit.
Please be seated. All right. We will pick up now with our third case, United States versus Eric Johnson. When you're ready.
May it please the court, Sylvia Tsakos for Eric Johnson. This case is about whether police officers conduct a Fourth Amendment search when they bring a drug-sniffing dog to someone's apartment door at 3 a.m. to sniff for contraband inside. They do under both the reasonable expectation of privacy approach and the physical intrusion approach. First, as the Seventh Circuit held in Whitaker, the sniff is a search because the drug detection dog is a super sensitive tool for detecting objects inside the home that police couldn't otherwise detect. As Justice Kagan explained in her Jardines concurrence, Kylo establishes that residents have an expectation that police tools not in general use will not be directed at their homes.
Counsel, can I just, that was a concurrence, and obviously if the Supreme Court or a Supreme Court justice wants to sort of cut back on Place and Caballos, all the cases saying that a dog sniff is sort of per se not a search because it can only uncover contraband in which you don't have a privacy interest. I could see how, following Justice Kagan's lead, the Supreme Court may someday decide to cut back on those precedent, but I'm not sure we can do that as a lower court. That's my concern.
It wouldn't be cutting back on the Caballos and Place precedent. Place and Caballos do not involve the home.
It would involve pretty radically I mean, it's characteristically Justice Kagan. It's very catchy, it reads very well, but that's a pretty radical reconceptualization of the ratio discendi of Place and Caballos. It's like, let's restate the whole theory on which those cases were decided.
I don't think so, and I
It
think
just, no, because those cases say this is literally not a Fourth Amendment event. It is not a search, and once it's not a search, the Fourth Amendment doesn't care. The Fourth Amendment doesn't regulate police conduct. The Fourth Amendment regulates searches and seizures. And once you say that something is not a search, you can stop reading, right? Because I know you're going to come back and say the home. He's like, but the Fourth Amendment doesn't regulate police conduct relating to the home. It relates searches and seizures of a person's home, person, or effects. So once I say it's not a search, the Fourth Amendment is done, right?
so. I have a couple responses to again the idea that this court would have to be cutting back on Caballos and the Place line of cases. I'd point the court to this decision, this court's decision in Hill, which says at page 251, Place obviously did not sanction the indiscriminate blanket use of trained dogs in all contexts. It's already.
Well, no, it doesn't, because it says once you've pulled someone over by the side of the road, which is a stop, a search, I guess a seizure, or search, it's a seizure, you can't detain someone indefinitely just to go get your drug-sniffing dog, because that's unreasonably prolonging what is already conceded to have been a seizure, which is pulling the car over. But here there's a question of whether there's a seizure or search at all.
That's right. The question is whether there is a search. But again, I know it sounds like Justice Kagan's concurrence in Jardines will only get me so far, but I would point the court to footnote 1 where Justice Kagan says that the Supreme Court has held over and over again that people's expectations of privacy are much lower in their cars than in their homes.
But not their suitcases. That's the other thing that I find kind of concerning. I mean, you have a very high level of privacy in your luggage, and that's what was going on in Place. And I don't think the court has ever said, oh, that's no big deal. I'll just open up your luggage in the middle of an airport and let everyone see what's inside.
Again, Place did not involve the home. Place did involve luggage, and I do think people have an expectation of privacy in their luggage, but whether it's reasonable when that luggage is in an airport, I think was the issue in Place in Caballos. I'd also point the court to the Caballos decision itself at page 407. It says the question presented is narrow. It says nothing about the home. It's about whether the Fourth Amendment requires reasonable, articulable suspicion to justify using a drug detection dog to sniff a vehicle during a legitimate traffic stop. I haven't found any published Fourth Circuit decision applying Caballos to justify a canine sniff at the home. And I'd also point out that the Supreme Court has refused repeatedly to take search doctrines that originate in a context like car searches, and to transplant it and sort of plop it at the home and say, this is okay here too. I think Cornelia is a great example of that, where the court said the community caretaking exception couldn't be just extended to allow warrantless searches at the home.
Do you also sort of make a property argument here too? So sort of, you started by saying there are two lines, and not to cut you off from the one that seems rather uphill. Can you sort of help me understand what your argument is under Jardines? Are you arguing that the hallway is property that he had a ownership interest, a right to exclude? Help me understand how I'm getting there?
Sure, yes, we are making a physical intrusion-based argument. The point is that the SNF physically intruded in the protected area immediately surrounding Mr. Johnson's home without license to do so. And
And when you say that, you sort of seem to be suggesting like a curtilage kind of idea.
Yes.
But I have always thought of, and it seems like the cases seem to agree, that curtilage is like necessarily like a subset of your property, right? Like you don't get curtilage because of proximity. You get curtilage because it is part of your property that's distinct from like an open field, right? The curtilage is the description of your property that's close as opposed to the description of your property that's not close. But it's a subset of property, right? And so what I have a hard time with in the hallway example is how the hallway is something where Mr. Is it Johnson?
Mr. Johnson, yes.
Mr. Johnson had a property interest, right? I don't mean ownership, right? That's different. It's apartments, I get that. But you have to have some property interest, sort of a right to exclude.
So I don't read Jardines or Collins to be requiring a sort of formal property analysis in that sense. The language that the court uses in Jardines is that the curtilage is the constitutionally protected area immediately surrounding and associated with the home, that it's intimately linked physically and psychologically.
But if you take the doctrine from the start, I mean, it starts with Oliver, which says you may have a right to exclude from this property, but it's so far away from your house, it's more like an open field, so it doesn't matter. But it's not a Fourth Amendment violation for the police to intrude on it. And then in Dunn, they're cutting back on that, and they're saying, okay, we said open fields, even if you own them and have the right to exclude, are not protected by the Fourth Amendment. But if it's a land right around your home, that's different. You have, not only do you have the right to exclude, but it is also home-like. And so I think I have the same question as Judge Richardson. I don't see how we can just plop the Dunn factors down where there's no right to exclude. It's as though the unstated most important factor, it's as though what Dunn is saying is most important, obviously, you need the right to exclude. And then within that category, we will say that an intrusion onto this property is a Fourth Amendment intrusion if you can also show that it's close to your house and it's an extension of the activities that you do in the home.
So a couple points. Dunn, I don't see a factor in there that says the
No,
right.
they don't say that, right.
Yeah.
But I'm saying that's the unstated premise, because in Dunn, that guy owned the property.
I guess I don't necessarily agree that that's the unstated premise. And again, I'd point the court to Jardines and Collins, which don't even cite Dunn or go through the factors.
Because it's obvious that is Jardines' porch. There's no allegation, like, that's not his house. I don't know what he's complaining about.
I do think probably in Jardines it was his home, but again, I'd say that the bottom line takeaway, as I read Jardines and Collins, is that the constitutionally protected area immediately surrounding and associated with the home. Here we have
So you think if you have like a townhouse and the front door opens immediately onto the sidewalk, that public sidewalk, that's curtilage and the police can't walk in it?
I don't think, I do recognize that there could be tough lines to draw about where does the curtilage start, where does it end, is it the sidewalk? I don't think that's a question that the court really has to answer here. Here we're talking about the threshold of the door. I think that at bare
But
minimum.
the threshold of his door is the equivalent of a townhouse that opens directly onto a sidewalk, right?
In your hypothetical, yes, and I do think in that situation, if there's a drug dog sniffing right at the threshold of the door, that space is curtilage. It's immediately
It just
surrounding.
seems a little bit bizarre to say that we would, applying a property-based approach, say there is a Fourth Amendment violation because the police have entered somewhere that is not in fact your property. That just seems weird.
I disagree again. Again, just going back
I
to
mean,
Jard.
we're calling it a property-based approach, but the police, how did the police violate my Fourth Amendment rights? Well, they did so by entering a place that I don't have any sort of property-based interest in.
So I think there is an interest in the space just outside your home.
But that sounds like cats. That doesn't sound like a property. That sounds like a reasonable expectation of privacy approach, not a property approach.
I do think the approaches generally point in the same direction, but I would point the court to the Texas Court of Criminal Appeals decision in Rendon, 477 Southwest 3rd, 805, and the Supreme Court of Illinois in Bonilla that both said, at minimum, the threshold of the door is curtilage. The idea that the home is sacrosanct and it's at the core of the Fourth Amendment, there's this space right around it.
So
Immediately.
the Texas case, is the Texas one, is that the like duplex or quadplex or whatever it is? So there wasn't a question there whether there was a property interest, right? Like if I live in a duplex, and so Judge Harris and I are right next door, I have a right to exclude people from our shared porch. I don't have a right to exclude Judge Harris, right? But I've got a right to keep you off of that porch if I am so inclined. And so that, I totally understand that in the Texas case, and I think it's also true in Illinois, that was a place that was a joint ownership, like a joint right to exclude. That seems like totally reasonable. But I haven't taken you so far to suggest that that's what you have, that Mr. Johnson had a right to exclude people from the hallway.
I don't.
Or in Judge Harris's earlier hypothetical, that the row house right on the sidewalk has a right to exclude people from the sidewalk.
So I'm not suggesting that Mr. Johnson had the ability to exclude people from the hallway, but I do think the area immediately outside his apartment was a protected space, and we can look at the picture at JA 106. The door was set back from the hall. There were 2 layers of security into the building. This is JA 363 and 404, and so it was, it is a protected space.
Well, but can I ask, you said 2 layers of security, 2 layers, the police didn't break in, right?
They did not.
Who let them in?
The management let them in.
Does the management have the right to let people into the shared public hallway of an apartment building?
I think they're able to do that, but they can't diminish the residents' Fourth Amendment rights.
Oh, it seems like they massively diminish the residents' Fourth Amendment rights because they have unfettered ability. Not only that, does your client have the right to prevent other people, other tenants, from letting people into the shared public hallway?
Not sure that he has that particular right in his lease, but I do think, again, with the reasonable expectation of privacy and the norms that we're talking about in the physical intrusion test, the Supreme Court in Jardine said that no one has the right to bring a trained police dog to your home just outside in order to sniff for contraband.
Well, so let me give you this analogy about the building manager. So I own my house with the person I'm married to. I have a right to prevent people from coming into my house. I have a right to prevent a drug-sniffing dog from standing on my front porch because my front porch is clearly part of my curtilage. But my spouse has the ability to let people in, and if she lets people in, I don't have any Fourth Amendment right to complain if my spouse lets people in. So why isn't the building manager here analogous to my spouse?
I think, again, we're looking at the perspective of Mr. Johnson and his home and the area immediately surrounding it.
Let's just posit that I could imagine being very, very cross if my spouse let a drug-sniffing dog into my house, and yet...
And why would you be cross about that?
I don't know.
We talked about the Fifth Amendment earlier. I don't know whether now's not the time, but maybe.
Or a police officer generally. I might be very cross if I learn that my spouse let the police into our house because I don't want blah, blah, blah. But, or a friend of hers that I don't like. I guess my point is, I could imagine being very, very cross at my shared tenant letting a variety of people into our house for a variety of reasons. But as a Fourth Amendment matter, I have no right to object to any of it.
I guess there might be a difference, though, between people living in a space together and then this apartment home where Mr. Johnson, it's not like the building management were sharing that particular space. But I also want to point out that letting officers.
But you do agree in the hypothetical we got here, if the landlord who has the key let the police officer into Mr. Johnson's apartment, right? That would be a Fourth Amendment violation, right?
It would, yes.
But doesn't that really sort of show us that there are property interests that Mr. Johnson has, which is like on the other side of that door, right? That the landlord can't get into and can't authorize law enforcement to get into, absent some unusual circumstances, right? That would be a search, even though the landlord can do that. And the landlord's the owner, but Mr. Johnson has the right to exclude the landlord and police from inside the door, but not outside the door, right? That line seems to be precisely where we say he's got a Fourth Amendment interest in his apartment, but not the hallway.
Well, I do think it follows from Jardines and Collins and the discussion about the area immediately outside the home. That area is sacrosanct because the home itself is sacrosanct under the Fourth Amendment. I'd also say letting officers conduct warrantless canine sniffs at apartment doors as long as building management lets them in sets a sweeping and very troubling precedent where police officers can basically gain access to a building. I see my time is up. If I could finish. Police officers could gain access to an apartment complex and basically take a drug sniffing dog up and down the hall, every single unit sniffing every single door until it finally alerts. And that's exactly what happened in the case from the Connecticut Supreme Court, Kono. And thank you.
Thank you very much.
Good morning, Your Honors. May it please the court, Ade Admirale for the United States. I'd like to start here, well, obviously, for the reasons for which I will discuss here, I respectfully ask you affirm the lower court's decision. Following on with Judge Harris's point, I would agree that indeed overturning the lower court's decision would, in a way, minimize place in Caballos. Specifically, the main points identified in those cases was one, there is no right to privacy in contraband. Here we have a drug sniffing dog trained, the party stipulated that it was trained as such only to sniff contraband, and that's at JA 373. And the cases are very clear that there is in fact no right to privacy in contraband. And two,
can I jump off of this and go back to the property question? What happens in a hypothetical where the police, in this case, except the landlord doesn't let them in, right? So the police officer with the dog stands outside the apartment until somebody walks in. They grab the door and walk in behind them, as people are wont to do, and then walks the dog around. But without consent or agreement or permission by the landlord. Is that a problem, a Fourth Amendment problem, when the dog alerts at Mr. Johnson's door?
Yeah, I would say, Your Honor, in this case, it's not just a matter of building management letting the police officers in.
Yeah, don't fight the hypothetical. Actually, just go with the hypothetical, right? So I understand that my hypothetical is meaningfully distinct from the facts of the case. I'm positing that on the front end, right? I'm positing management doesn't know or authorize it, right? But otherwise, we've got what we've got, right? And so I guess what I'm trying to understand from the government's perspective is, in your view, is there no search that's taken place? Or would Mr. Johnson simply lack standing to assert any Fourth Amendment violation? maybe the landlord might have a Fourth Amendment violation because he has the right to exclude from the hallways. But maybe Mr. Johnson lacks the standing to assert it. Or is even in that instance, there's no search that has occurred. There are two ways of thinking about that. They sort of end up at the same place, but I'm curious from the government's perspective, which one you think is the right way to think about it.
Sure. Even if the police officers weren't allowed into the location, the government would still say that a search has not occurred. And that's because of a number of factors here. Here we have a large complex building, over 100 units identified in the record. We have multiple floors. I believe there are 4 floors in this apartment building. The apartment 201 in this instance was specifically right by an elevator, which was used by guests, cleaners, apartment management, other individuals who live in the apartment.
Okay, but imagine that the dogs go into the hallway and actually sitting like on the edge of the hallway is a kilo of cocaine, and the dog alerts on the kilo, and they charge the landlord. Because as it turns out, the landlord's a drug dealer and he happens to keep his drugs in the hallway. It's probably not gonna be a drug dealer for long, but bear with me. And the landlord said, the person that owns the building says, these are my hallways, like I own them. I give license to some folks to come and go, but I didn't give the police officer license to come and go. Don't you think the owner of the apartment complex could assert a Fourth Amendment violation for the drug dog that found the kilo in the hallway?
And that may be so. And as your honors have identified, the property side of the analysis may also include who owns the property itself. And there may be some legal formation issues there. I mean, right, I don't know who the owner of a particular apartment building may be, and how you associate the drugs to a particular individual. However, I don't think it's, I don't necessarily disagree with your honor in that the individual who has the ability to exclude others from the location may in fact be the one with the Fourth Amendment right in that instance.
Can I ask you to just sort of address where your colleague left off? If you're right, is there anything that prevents the police from coming into the building? Let's pause it with the acquiescence of the landlord, a 100-unit building, and just marching the dogs through the hallways to see if they smell anything?
I'm sorry.
Is there anything that would be problematic about that? Or if you are right, does it follow that if the police want to, they can just have a day where they all fan out into different apartment buildings with their dogs and see if anything turns up?
I can't think of an example in which there's an apartment building, certainly one of this size, but an apartment building with common hallways,
Yeah.
elevators.
So it's fine, you just
others-
have to, that's the cost of our property-based approach. If the police want to do like a drug sniffing dog dragnet and just take it, fan out across the city into every apartment building, no reasonable suspicion, nothing like that, that's all fine.
Then, Your Honor, I wouldn't characterize it as a cost. However, under place in Caballos, as long as the drug sniffing dog indeed is only able to sniff drugs and isn't looking to non-contraband.
Yes, it's
And then
fine.
on the property side of the analysis, we've gone over the.
That's also true at like a music festival or anything else, right? That like, if you're in that setting, then, they could bring the drug dogs there too.
Indeed, on the property side of the analysis, if the.
Or
if law-
explosive dogs, right, would be the same inquiry.
Do the dogs explode or do they sniff good explosions?
Well, if they're not good at sniffing, then they end up exploding.
I would agree with all of those examples, Your Honor.
So what rule do you want us to adopt? We have to define curtilage for purposes of this case. How would you define curtilage?
I'd like your honors to simply follow Makel. In Makel, Makel is on all fours with this case. It is indeed an unpublished decision. I'd like your honors to turn that into a published decision.
Well, but we don't.
Excuse me.
No, finish.
And indeed, the curtilage is simply the four corners of an apartment. The common hallways An individual who lives in any particular apartment doesn't have the right to exclude anyone from those locations. Indeed, as I've said before, guests of other apartments are able to
So
come
is
and
that the
go.
rule that you would have us adopt, that you have to have a right to exclude in order to have a sufficient property interest for something to arguably be curtilage?
Specifically, again, and if if the two statements were contradicted one another, excuse me, in Makel, it makes it very clear, particularly on the on both sides of the analysis, but as we're speaking to the property analysis here, Makel explicitly states, and I believe this is a quote, "The common hallway of an apartment building, including the area in front of the door, was not in the curtilage of his apartment." I'd like this court to simply take that language, put it into a published decision, adopt that as the rule, and have that be the rule for the Fourth Circuit going forward.
But let's just say if it's a published decision, we're gonna need another sentence saying why that is so. So, okay, the hallway outside the apartment is not curtilage because,
One, and as I've mentioned before, there is no individual in any particular apartment that can exclude a visitor, a guest, cleaning staff, and in many instances, members of the public from entering into those common spaces. There's no part of the privacy of your life that extends into a common hallway when you're living in an apartment building. When you have an apartment building, particularly one of this size, is more
Can I-
akin to a hotel.
Can I ask a hypothetical from a case that we decided called Jackson from 2013? And as I take the hypothetical, there's like an apartment, and the apartment is on the ground floor, and the ground floor apartment has a patio, which I took to be like sort of a poured concrete pad. And the court there assumed, without deciding, that that patio was part of the apartment's curtilage. Do you agree with that? It then went on to decide that once you got off of the patio, there was some grass apparently, and that grass was not part of the curtilage because there was no, it doesn't exactly explain why, but in our hypothetical, it's because they had no right to exclude. But they did have a right to exclude from the patio, right? Like if somebody else showed up and wanted to put their barbecue grill there, they could be like, no, you can't barbecue grill on my patio. Do you agree in that sort of a setting, if you had an apartment on the ground floor with a patio, that patio would be part of the curtilage? That's exactly what we would think of as being the curtilage?
Yeah, I do agree, Your Honor. But an individual on a patio such as that may have a table out there, may have a couch out there, and other items that are theirs, similar to maybe you have a balcony in your apartment, right? I also would agree there. However, and on top of that,
And the reason for that is the reason simply that you have the right to exclude people from it? Or is there something else? I'm trying to maybe get at the same question that Judge Harris is, which is when we say, in opposition to what she said earlier, the hallway is not because the patio is the curtilage of that apartment because of what?
One, it is indeed, again, the right to exclude. On the flip side, maybe of the same coin, the apartment management can't give permission for an individual to go into the balcony of your apartment or go into the patio area of your apartment. The two of those, I think, are critically important facts, not just for this case, but other cases going
yeah, and we
forward.
say in Jackson that we are identifying the boundary between the property that was conveyed by the lease and then the common area. So I think the idea is that the patio is part of your lease. The enjoyment of that patio comes along with your lease. So I do think we ground it in Jackson and that kind of property idea. Can I ask you a question? What if, so we know that, on your understanding, the area in front of the, Mr. Johnson's apartment door is not curtilage. What if they have like a kind of sluggish, drug sniffing dog and they need to stand out there for like 5 hours, just sniffing all around the seams and it hasn't alerted yet? How long can they stand out there? Is there any property-based right, any understanding that would allow a court to draw a line and say, look, it might not be curtilage, you don't have the right to exclude, but they're not allowed to just stand outside your door all night.
Right. And maybe, given that Your Honor has identified, maybe a lease agreement as a way in which to look at some of these property issues, in many leases, and including in this one, I believe, there's a commentary around, individuals can't just stand out in the hallway and have a party all night, right, or for many hours on end. In this case, indeed, I know you've raised a hypothetical, and I hope I'm addressing that, but in this case, indeed, we have a fairly quick search. I can understand if there may be
But
some.
like I don't understand the lease point, right? Because the lease point, if there's, like, imagine there's like an anti-loitering or a noise issue, it seems like those are things, the landlord can surely enforce those things, right? But they're not creating a right on behalf of the apartment owner to exclude, or apartment lease holder. That's a right the landlord has, right? So if you're loitering in contravention to your lease agreement, like, that's as between the landlord and the loiterer. Like, there's not a third-party interest that would allow an apartment leaseholder to exclude somebody for loitering, right?
That's correct, Your Honor, and excuse me if I wasn't clear about that. Again, in the instance of apartment buildings, the apartment owner or the management company, the Fourth Amendment right, certainly in the common hallways outside of the apartments themselves, apply to that management company or owner. The right in the common areas, such as the hallway in this instance, doesn't apply, put forth, to any particular renter or lessee of an apartment itself.
So the answer is the police officer, there's no Fourth Amendment problem, at least with the police officer just standing outside the guy's door all night and all day.
As long, as in this case, where they were allowed authorization to enter into the apartment, and I'd also submit the private investigator in this case was also given authorization to enter the apartment, I believe, without even making it clear what he wanted to do, then yes, there really is no
You'd say
time
it's the
limit
same,
upon which.
it's the same answer, like, could the police officer stand on the sidewalk outside of, if I happen to have a sidewalk at my house, but stand on the sidewalk outside my house? As long as it stayed on the sidewalk, the police officer could, in theory, conduct surveillance from the sidewalk as long as he wanted to be there with drug dog or whatever it might be.
That's correct, Your Honor, and that follows.
It seems a little different if you're talking about, like, let's just use the Jardines house. Like, so the police officer can stand on the sidewalk some distance from your home and kind of stake your home out, as long as he wants. Maybe it's a public sidewalk, but if he's like literally right outside your door, I do wonder whether, you have some kind of a right to use and quiet enjoyment or something like that, where actually, no, he can't just stand right in front of your apartment door. And so that you have to like walk past him, under his arm every morning. Like that, at some point, isn't there some kind of common law, traditional thing that's gonna come to your rescue?
There may
Because
be.
if there's not, I start to get really troubled about what we're saying about apartment dwellers.
Sure. And there may be a contractual right as identified in the lease agreement or otherwise. However, still nonetheless, I put forth that there's still no Fourth Amendment constitutional right. And there is some distinction there, and this is why maybe I had a little bit of consternation with fully going forward or agreeing with the lease as kind of the identification of your Fourth Amendment rights. And under that instance,
Oh, so
there
you
may
think
be
the
a
lease
civil.
might give you more rights than you actually have under the Fourth Amendment?
Or less. I mean,
Okay.
those are the separate issues that may be brought in civil litigation. For Fourth Amendment purposes, Place, Caballes, Makel, Fitzgerald, these cases have made it fairly clear,
In what way, can you go back to that point? In what way, we don't typically think of like, in what way would a lease give you more rights? Like, how could that, I mean, I understand in the example of like the patio, right? The lease is included in the property that I'm leasing. Is there another way that the lease gives you more? Is there another way that you can think of that the lease, I mean, I understand the patio example, and in that sense, it's giving you more property interest than you had. But is there a way that, independent of that, the lease could expand the Fourth Amendment rights that you have?
No, and forgive me if there was any misunderstanding there. The lease, again, just to be clear, the lease may have impact and effects with respect to, civil litigation or some sort of civil right. However, I certainly wouldn't submit that the lease has any, significant or predominant impact over an individual's Fourth Amendment right in an apartment building such as this one here.
Except insofar, I take you to agree, except insofar, it defines the property that is yours, right? So the lease example that we gave in Jackson, it included the patio. And so if it included the patio, like, that means the lease, in the same way it's giving you the inside of your apartment, it's giving you that patio too. So the lease could well determine the scope of your protected area, right?
The lease certainly informs the Fourth Amendment property side analysis and the privacy side analysis. Certainly the lease informs that, but it's not determinative, and it's certainly not the four corners of your Fourth
Right,
Amendment
because it
right.
might give me rights against my landlord that I don't have without giving me curtilage, basically.
That's correct, Your Honor.
Huh.
And with that said, we'd ask again that Your Honors affirm the district court decision, and if there are no other questions, thank you.
Thank you.
Thanks, Your Honors. I'd like to make a couple points. First of all, I didn't hear my friend on the other side articulate any kind of limiting principle. They seem to fully embrace the idea that police can get access into an apartment building if, just as long as management lets them in, they can walk a drug dog up and down every single unit, hundreds of units in Mr. Johnson's building. That kind of rule cannot be squared with what the Supreme Court and this court have said over and over about how the Fourth Amendment at its very core is the home and how the home is entitled to special protection under the Fourth Amendment. And again, I'd point this court to the decision in Hill that rejects the idea that place, and in that case, the court discussed Jeffis, which is essentially the Kabbalist equivalent, but it rejected the idea that, that those cases and the logic can be basically authorize indiscriminate dog sniffs. I also want to pick up on a question from Judge Richardson about the music festival. A music festival and a very public setting like that, it's very distinguishable from the home. And I'd also, I want to pick up on the discussion about Jackson.
Well, but in our case, sort of a question about whether it's distinguishable or not, right? I mean, the question, there's no doubt that, like, one side of the door is the home, right? And that there's no doubt that you cannot go inside the home, right? The landlord can't go, the police can't go, absent process, right? It seems like to me that's totally fair, and to think that that is protected is absolutely correct. Like, the question that we have is whether the area outside that is part of the home or not. Like, your comments, which I understand where you're trying to go, but your comments sort of presume the answer, right? That, like, the area outside the home is the same as the area inside the home. And maybe there are arguments in the sort of reasonable expectation of privacy line of cases there. I understand there, but in the property line, that seems like a really hard line to draw for you.
So I don't think it's just all the area outside of the home. In our case, I do think really we're just talking about the threshold. And I think actually if the court were to say, just look at the lease, what does it say? Those are the four corners of the apartment or whatever it may be. That kind of rule actually seems stricter to me than even the done factors. The done factors don't say, what are the bundle of sticks that the resident has? Do they get to exclude? Do they not? I think also.
But that's because Mr. Dunn owned the property. I mean, I just think that the court was able to take for granted in Oliver and then in Dunn that he owned the property. They were trying to figure out which parts of the property he owned were going to be protected under the Fourth Amendment.
I agree that it does seem that in those cases, the person, the resident, actually did own the property. But again, I don't think this court has limited the analysis in that way. I don't read Jackson to be saying, you know, could the person exclude from this area, open, shut, and it's done, just based on that analysis. And I'd also.
Well, but Jackson actually doesn't do anything with that, right? It assumes that the patio is the curtilage. And that didn't matter to its analysis. I think that's the right analysis. I think that assumption was correct, but it's not really sort of holding that because it finds that the trash cans weren't on the patio.
That's correct. But again, I do think that is very different from the case here, recognizing the lease and the property and all of that. We're talking about right out front of someone's home. And again, I don't think that kind of rule, that a sniff, may I finish? That a sniff outside an apartment door home can be squared with the Fourth Amendment's special status, or the home special status in the Fourth Amendment, excuse me. Thank you. We ask that that the court vacate Mr. Johnson's conviction and sentence.
Thank you very much. We will come down, greet counsel, and then hear our final case. We will hear argument now in our last case of the day, Priority One versus CDK Global. And Mr. Castellano, we'll hear from you.
Good morning, Your Honors. Carmine Castellano for Plaintiff Appellant. Your Honors, in this case, the applicable contract provision has two parts. First, CDK is prohibited from using Priority One's data to create revenue-generating services. Second, CDK is prohibited from using Priority One's data to supply revenue-generating services.
Just because because of where you were starting, can I ask a clarifying question? So as I understand from your papers, the use the use theory here is that this I can't remember what it was called, this new Security First program is designed to protect data, or at least it's sold as protecting data. If there were no data, there'd be no program, and in that sense, it is using the data.
That is correct, Your Honor.
Okay. So then, if that's the theory of use, what is the difference between the creating and the supplying?
Sure. It's very similar, if not the same, as what happened in this court's case of Dave & Buster's versus White Flint Mall. In that matter, Dave & Buster's opened a competing facility within the radius restriction of the lease. And what the court held was that not only was it the opening of the facility, but the daily operation of the facility, which was the continued breach.
But what did the contract in that case forbid?
It forbid the opening, I believe, of a competing facility within the radius restriction. And what this court held was that it wasn't only the opening of that competing facility, but its daily operation that constituted a continued breach and thereby applying the continuing harm doctrine.
So I get that, and this may be just like a little thing I'm having trouble following, and I'll drop it in a second, but if that's your theory, I guess I still don't understand why the create versus supply thing makes any difference,
Well,
one way or another.
sure.
They started this program, and I gather,
Sure.
on your White Flint theory, every day that they invoice for it, they breach the contract anew.
Absolutely, and this is what I want to explain. So there's two different theories here. So one, if you split up creation and supply, the creation of Security First happened in 2015.
And that seems like a long
But,
time ago.
but I'm sorry,
Go.
no, go ahead, so
So that's my question, like, if
they
you,
use the data to create it.
right. That seems like that was well outside the limitations period, right?
The creation?
The creation, yeah.
Yes, but not if you apply the continuing harm doctrine. So if the creation.
Well, and that would have to be continuing harm, not continuing violation. because again-
Correct, so the continuing harm would have to apply. If you only look at one breach, which is the creation of the Security First initiative, then you have to then apply the doctrine. If you split creation and supply took place from 2015 through 2022 on a monthly basis.
But the use was kind of leveraging the existence of the data to stand up this program that you said was protecting data, but then you supplied
Better
the
language
data?
would have been relied on priorities data in order to create this revenue-generating service. And all you need to look
Wait,
at.
I'm sorry, I think
Yes.
you just said relied on to create, that's what you think supply means?
No, Your Honor.
That's what I'm
So-
having a hard time understanding. What do you think the word supply
Yeah.
means? Posit there are like two plausible
Yeah, supply-
ways to
supply would
think.
be-
Okay, let me finish before you start going on.
Yes, Your Honor.
So posit there are like two possible ways to think about supply, right? One way to think about the phrase is sort of to make something available, right? But the other is to sort of like to make additions or the like, right? And so one of those suggests that, we're supplying by putting it in, like you supply the data, take AI as an example, I'm supplying the data to AI in order to let it learn. And the other way to think about supply is that I'm supplying something to a customer, right? But one's like the inclusion of data and one's the like something outward focusing. Why? I take your arguing for the second, but I'm not sure why that is, as opposed to sort of reading these two words really to sort of have a very similar meaning, right? Which is, to create and supply, to use the data to create and supply the service.
Correct. So the use of the data by CDK, at CDK relying on that data in order to create a service. Without the data, you're unable to create the service.
I got that.
And supply the service, Your Honor, and supply it. So again.
Wait, explain the supply. So your
Yes.
theory of the use, just go back, your theory of the use is they kind of relied on the data to stand up this program because it allowed them to say this was for protecting data. That just sounds like your theory of use is about creating the program. In what sense is your theory of use about using data to supply, you're using the data to supply services?
Absolutely, Your Honor. So the creation of this initiative took place in 2015. You have to implement it each month. So in the record.
So each month they have to once again,
Supply the so-called security services and secure integration, which is
So
why
each time you
our
s-
third-party vendors were charged each month, and there's an Excel spreadsheet in the record at 3068, which comes from CDK's files, which shows what they charged all of our vendors each month from 2015 through 2022. And they charged for the supply of the enhanced security services.
okay.
And without our data, there was no need to secure the integration.
Okay, so basically each month they are once again saying, this program is here to protect data, and in that sense, they are using the data.
And, correct, and we can track this on a monthly basis by vendor, by priority one store, in a CDK spreadsheet, which is in the record at 3068. They were charging for something, and what they're charging for is the implementation of the Security First program. As they say in their papers, they had additional staff, there were new technological tools that they used to secure integration, and so they charged on a monthly basis all of our third-party vendors in a 7-year period, which can be tracked in violation of the contract.
Can I ask a different question? So you seem to assume that this sort of continuing harm doctrine, to the extent it's a doctrine, applies to contract claims. I read the highest court of Maryland in Kane to at least strongly suggest that that's not true. Can you help me understand why I should ignore Kane and even sort of reach these questions as opposed to simply taking Kane and making my best eerie guess that that the highest court of Maryland would not sort of apply this doctrine in the contract breach case at all?
Absolutely, Your Honor. Again, in Dave & Buster's versus White Flint Mall, this court did just that. It applied
So
the
I pulled David
continuing-
Buster's, and the only thing this court says in that very brief unpublished opinion is that the contract barred them from operating a facility. And that strikes me as pretty obvious. Every single day the White Flint location is open is a new breach, because the breach is operating. So that doesn't seem, that's not continuing. That's literally every single day you open the competing store is a new violation of a contract that forbids you from operating a competing. So that doesn't seem to help you.
In the same way that our contract
It's also
forbids-
before Kane, right? So like, to the extent you think the best authority you have to ignore the highest court of Maryland is an unpublished Fourth Circuit case that came out before the highest court of Maryland, you have another argument, or do you just want me to rely on that?
I have Chevron, and in Chevron, it was all, the doctrine was also applied. In a contract case, there was also statutory violations.
I thought that was the continuing breach theory. Is part of what's going on here that at least in most states, continuing harm doctrine and continuing breach doctrine are two different things? And I thought it was pretty clear that Maryland, in the Singer case, had adopted continuing breach.
Correct, Your
Continuing
Honor.
harm is different, and
So
tell
if
me if there's a difference between those two doctrines as they apply to this case.
there are. So if there is one breach, which is the creation of the Security First initiative in 2015, then continuing harm doctrine would apply. If the applicable contract provision is split between the creation of Security First in 2015 and its continued operation on a monthly basis, the supply of those services and the charging for those services, then Singer applies, and you have multiple breaches that restart the statute of limitations.
So can I start, you cite the court's decision in Singer as if it's the highest court of Maryland. It is not. So despite your efforts to suggest it's the highest court of Maryland, it's not, and it's an appellate court. And it predates Kane. So can I come back to the question, and I'll give like one last chance, and then you can move on to other things if you're interested. The court in Kane pretty strongly, over a, you might say, very persuasive dissent, tells us that Maryland doesn't apply the continuing harm doctrine in contract cases. And so you've cited a district court case from 2015, an unpublished case from 2015, and a lower court decision to say that I should ignore Kane. Is there anything else? Do you want to try to distinguish it, or do you just want me to make my best eerie guess that those other decisions better reflect the views of the Supreme Court of Maryland?
Well, in Kane, the Supreme Court did not come out with a rule that the continuing harm doctrine could not be applied in a contract case.
Sure, but it also definitely doesn't say that it can.
Correct. So if it can or it can't, it's an open question, I believe.
Can I'm so sorry, I am really stuck on why it matters in Maryland whether continuing harm doctrine applies, because I think it matters in most states, because continuing breach theory, under a continuing breach theory, you would be able to go back 3 years in time, right? Because it would start a new statute of limitations. Your most recent invoicing starts a new statute of limitations, and so you can go back 3 years. In most states, continuing harm doctrine is different. The statute of limitations are told, the accrual date of your claim is postponed, and when you do sue, you can go all the way back for damages. But it looks to me from Kane, like in Maryland, it doesn't make any difference. Either way, you can only go back 3 years.
I think that's correct.
So-
Under either
Right.
theory, you can only go back
So
3
in this
years from
case, and
when you
also,
file.
anyway, even assuming continuing harm applied to contracts in Maryland, your continuing harm is the continuing billing. Like, that's the only thing you're pointing to. So it just seems to me that I don't see what you would get out of it. I don't know why you are bothering to argue that the continuing harm doctrine applies, because I don't see what you get under it that you're not already getting or not getting under the continuing breach theory.
I agree with Your Honor. I agree. That was my first, the supply, the creation and the supply. And if you continue to supply, it's excessive breaches under Singer, which restarts the statute of limitations. I agree with Your Honor. What the district court judge did was hold there's a single breach in 2015. So under that, in the alternative, my argument would be under.
Okay, so if you have lost on continuing breach, then you want to be able to come
That's
in.
correct.
Okay.
My argument is that it's a successive breach every month, which can be tracked in Joint Appendix 3068. And the last point I want to make, if you want to understand the intent of the applicable language in this case, you just need to look at the very detailed affidavit from Jane Copeland, who drafted it, who was Priority One's DMS consultant, who has over 40 years' experience. My time has expired, Your Honors.
Thank you.
Thank you.
We've got time on rebuttal.
Good morning, and may it please the court. Michael Scodro for the appellee CDK Global. I think it's important to draw a distinction. In talking, the early questions from the court involved a little bit about how this works. So 3PA is the system of integration that had been around for a long time. I believe it's since 2000. And was an option for vendors to sign up for, and it would allow the vendor to sort of seamlessly connect with clients, the DMS that are owned by, or used by, rather, clients of CDK. What changed in 2014 through 2016, as alleged and as the evidence showed in its summary judgment, was there was this security first. Well, what is security first? Well, both parties describe it the same way, and namely, security first was an initiative to exclude anyone who wasn't using 3PA. Again, 3PA had existed. They'd been charging vendors to use it. As if you're a member of 3PA, what this changed with Security First was the prices went up in connection with the heightened scrutiny or heightened security. What was the form heightened security took functionally? It was ensuring that everyone accessing a CDK DMS was doing so through 3PA. So that is the change. And what's critical here is that ended for this user, Priority One, just a couple of weeks after they complained about it in November of 2016. So at that point, their data was no longer ever again subject to the requirement that only 3PA vendors, those who are using members of the 3PA system, could gain access to their system. That began and ended in 2016. Now, they've claimed that there is an ongoing ill effect of that, namely that vendors that use 3PA are being charged more than they were in 2005, in 2010, 2015, by virtue of Security First. Now, it is unclear how that is the use of
Priority One's ongoing use of Priority One's data to supply a service. But even if it were, and this now goes, we don't need to get this far, but if we get into whether or not there's a continuing breach, this case is Curry, another unpublished decision from this court, or it's the published decision from.
Can I ask what your understanding of Maryland, so across the country, sometimes the words continuing harm and continuing breach are used to mean the same thing, and sometimes they're used to mean a different thing. I take Maryland to have only adopted what I would personally call a continuing breach, but what Maryland says is the continuing harm doctrine permits recovery by an injured party caused by a tortfeasor's sequential breaches of an ongoing duty, imposing a new limitation period for each breach, right? This is the continuing breach idea.
Yeah.
Do we think that doctrine, even though they call it continuing harm, it's really a continuing breach doctrine? Why should we think that applies to contract claims at all? I mean, Kane seems to suggest that it would not and does not. The lower court case in Singer maybe in some sense could be read in contravention of that, but it's an earlier lower court decision than Kane. Can you help me understand am I thinking about this the right way and piece this together?
Yeah, let me give you my best answer to that, because I think it is a bit confused in the case law, frankly. I think that the terms, as we point out in our brief, have been used interchangeably and somewhat confusingly in some of the case law. I think that Your Honor is right, as we say in our brief, that in the contract context, the easiest way to reconcile the different cases in Maryland appears to be the understanding that the continuing harm in a breach of contract context is in fact the ongoing or repeated breach. And I think that goes to the quote Your Honor just read from their case law. And so I think that there's a strong argument to be made, frankly, that the language in Kane in foreclosing, and again, definitive Maryland decision in 2021, in foreclosing the use of continuing harm in the contract context, or at least suggesting that case law to date does not embrace the use of continuing harm in the contract context, that applies equally to continuing breach. Now, if the follow-up to that would then be, and taking the remainder of Your Honor's question, what about Singer? I think there are two answers. Singer, being a lower court decision that predates Kane, is part of the answer. I think the remainder of the answer, though, is Singer is a very different decision. Remember, Singer was a case, and I can change one fact in Singer to make it look more like our case, and I think it comes out very differently. Singer was a case where there were repeated, unpredicted, of different lengths and different times, electrical shortages by the utility. There was not in that case. So each one of those was its own act of, out of the blue, we have this breach of the duty to provide, electrical current. If they had said at the outset, every week at 2 o'clock, we're going to cut power for 15 minutes, even if that were...
But in that downstream, I totally get that distinction, but that distinction is to say, if you adopt the continuing breach theory for contract, then you should only adopt it per Williston and New York's sort of majority rule, which is that there have to be successive distinct breaches.
That's
correct.
That's
downstream of the question of whether it applies to contracts at all.
Completely agree. So I would say my first answer is Kane should be read, in terms of making an eerie guess, the sort of respectful decision, the one that does not go further than the Maryland High Court would be to say, look, the Maryland High Court or the Maryland courts conflate these doctrines in the contract context, and Kane has suggested that these combined doctrines apply, although it referred to it as harm in that case, don't apply in a limited set of basically property-related cases, right? That would be our first argument, and I think that's a full stop. If the court were to disagree with that and say, we do think that Singer is something that needs to be accounted for, and there's room in Maryland law, again, we would disagree, there's room in Maryland law for something where you have successive breaches of contract. a la Singer, we would say that still has nothing to do with this case. Putting aside the fact that the misconduct alleged here ended in 2016.
Can I ask a question? That if I read Kane as expansively as it might be read, would that affect the scenario where I'm a buyer of coffee beans, and I've got a 3-year contract, and you fail to supply me the coffee beans for 3 months, and so I then sue you, and recover, and you then start supplying beans again, and then outside the statute, you stop supplying beans for a second time? Can I still sue you a second time? It's not a one contract, one suit idea, right?
Right, and I think that's where, I think if Kane is read at its most expansive, it may well preclude that. The reason I'm adding Singer is I think that would be the most expansive reading. But if you have a reading that contemplates, that leaves some room for what Your Honor describes, I think Your Honor is describing the Singer scenario, and I think Kane can easily be read to allow that to persist, that claim to persist, without doing violence to that, while still eliminating both harm and breach as plaintiff is using those terms in this case. I think in this case, so if we blow past everything and we say, look, yes, they're still using your data even though you went on the Do Not Disturb list as of November of 2016, even though immediately thereafter a non-3PA member vendor started using, again, integrating and taking data from the Priority 1 DMSs, someone who was now free to do so yet again because we had put them on the Do Not Disturb list. Even if, that was called Authenticom, even if we put all of that to one side and we say, you know what, let's imagine there's a contract provision that says you should not increase, you've been charging for decades prices, or 15 years at that point, you've been charging for 3PA membership for vendors who opt into 3PA. Let's say there were a contract provision that said you shall not ever increase those prices, because that's the complaint, that they went up in 2016, they knew they went up in 2016, they don't claim there's been changes since then that they're alleging are independent problems. Even if that were the case, then, and even if we think Kane should be sort of disregarded and we can look to a full-bore kind of continuing breach, continuing harm scenario, then this is Curry or General Insurance, this court's decision from 2018. Then it's a case where you have, and all of the district court cases we cite on pages 32 and 33 of our brief interpreting Maryland law, then it's a case where you have either a monthly underpayment or a monthly overcharge to a would-be plaintiff, and they claim that with each monthly overpayment or undercharge, they're entitled, that sort of re-ups the limitations period, even though there was an announcement at the outset, or it was clear at the outset, that this was going to be happening every month. Their CFO testified they recognized the increases for 3PA membership in 2016. And so even if we go past all of what we've been talking about, this is still just then a Curry case. It's still just a General Insurance case. And not surprisingly, the two cases on which the district court most heavily relied for its decision. And I should add, its decision is totally correct, and it didn't even need to go to the next step, which is to say, and by the way, there is no continuing breach because we took you off the we put you in the Do Not Disturb list, and therefore we're not using your data for anything after that point in time. So there are multiple layers here, but the district courts would be the first. Kane would be an independent ground to do it. But even if we go past all of that, we're in a world where this is no different than all of the many cases, the ERISA cases, the district court cases, Curry, General Insurance, where it's made known that you're going to be paying more per month, and you may think that is a violation of a contract, but you knew it when it was announced that would be true, and that, under those circumstances, you're not given the benefit of either of these continuing doctrines.
So part of my challenge here is I continue to struggle with what exactly their theory of breach under supply is, but this is a hypo I've just been mulling, and I apologize if there's an easy answer that I just don't know. So, and I realize this is going to be about patent law, not about Maryland law, but I'm just trying to understand like how this would work in context that seems sort of like this one, right? So like imagine that a small pharma company thinks that Pfizer used some of their patented technology to create the COVID vaccine. Let's get away with discovery rule. Let's posit that the minute the Pfizer vaccine goes on sale, this small company is aware of this fact, right? And so Pfizer sells the COVID vaccine, and they sell it for years and years and years and years and years. Like, do you know what the answer would be? Like, is every single act of, under that circumstance, every single sale of the COVID vaccine patent infringement? And does that mean that you could not just sue them for future sales, but you could actually go all the way back to the first sale of the COVID vaccine? Do you have any idea how patent law would analyze that?
I don't, Your Honor. It's a great question.
But I'm just trying to think about like
Yeah,
other analogous
right.
situations of a claim that would look kind of like this.
Right. And to be sure, as Kane itself would recognize, if that were, I mean, I think the question is that better analogized as the sort of trespass, the classic continuing tort property claim that Kane acknowledges? Is it closer to that? Or is it closer to a circumstance where you have monthly payments and you well know they're going to be less than you'd like, or you're going to have to pay more than you'd like, and you don't do anything about it for, in this case, 4 years? And I think that would be the analogy, but I can't say how courts have come out on the answer to Your Honor's question on that.
Can I ask you a somewhat far afield question? But what happened with the unjust enrichment claim in this case?
So my understanding, the unjust enrichment claim is still, I want to make sure I answer Your Honor's question, to be correct.
Oh, just, let me,
Sure.
my only question is, I didn't see the district court talking about it anywhere. Is the district court assuming that the same limitations period analysis would apply to the unjust enrichment claim, or did it just fall through the cracks? What happened?
I think that's been the parties' mutual understanding, Your Honor.
I'm sorry, which one?
Oh, I'm sorry, that's a good point. The former, which is that the court essentially understood that it was disposing of both on the same theory. And we certainly would agree that any of the theories we've talked about today would dispose of it.
And is there, just so I'm clear, I think I know the answer, because Maryland has this statute of limitations that applies to the contract claim is a generally applicable Maryland statute of limitations that it presumptively applies to everything?
That's correct, Your
So
Honor.
there's no reason or even particularly plausible argument that unjust enrichment has a different statute of limitations?
No, that's exactly right, Your Honor. In fact, so we cite the Kane decision itself mentions, and as we point out early in our brief, the Kane decision mentions that unjust enrichment in Maryland is also subject to the same 3-year limitations period.
So if you went back to the district court and hypothetically had said, like, I noticed that you didn't dispose of the unjust enrichment claim in the sense that you don't literally explain why you're dismissing it, you expect the district court judge would have looked at you and said, really? I read an entire opinion explaining why.
Yes, that is what I anticipate would be the reaction, I would imagine. If the court has no further questions.
Thank you.
Thank you, Your Honors.
Your Honors, very briefly, just a couple factual points. Prior to the introduction of Security First, Priority One was unaware of any charges, any integration charges. It's when the Security First initiative was first introduced and all these charges came into play, and it was a big industry outcry and statutes were enacted and things like that. That's when we became aware of it. So prior to that time, we were not aware of any integration fees. The other issue is that simply because one vendor was put on a do not disturb list, that's not our only theory of breach. We were continued to be charged from 2015 through 2022, or our third-party vendors continued to be charged, and that is also a breach. We also were never told.
Do you agree, though, that you knew about that as of when? That your vendors?
2016.
2016.
That's correct.
And are you suggesting that there's something different that happened after 2016, or is it just the same, in your view, the same breach that's occurring every time you get a bill?
We don't receive the bill gets given
Not
to
you
our
get a bill.
vendor.
Right.
Generally, yes, but the amounts could be different and the
Yeah,
vendors
amounts are
could be
different, but it's the same-
But generally speaking, yes, correct.
Yeah.
And so, again, each month, that is a breach, a successive breach, and when we file, we can't go back more than 3 years with respect to the damages. So it's not forever. When you it keeps the statute of limitations open, and when you file, you can go back only 3 years from when you file. If the court has no further questions for me. Thank you.
Thank you.
We will come down and greet counsel, and I'll ask that court be adjourned for the day.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.